Good afternoon.
Good afternoon.
Welcome to this.
Chair.
Thank you, Senator. Welcome to the Senate Finance Committee. Today is Tuesday, March 3rd. We are going to hear 14 bills today. We ask that the sponsor of a bill can take as long as they need to present the bill. The witnesses each get 2 minutes. If you hear the buzzer or see the light, please finish your sentence. I really don't want to gavel you. I'd rather you be respectful of the other 90 people coming behind you. So it's going to be a big day today. But thank you all for being here. I'm going to read the bill order that we expect, although we have senators going to other committees to present bills. So it just depends on who's present. Senate Bill 742 is at the table. 721, 778, 806, 942, 773, 874, 915, 917, 39, 562, 892, 663, and 568. It's going to be a long day on the Finance Committee. Senator Gazzoni, you're going to present Senate Bill 742, Maryland Medical Assistance Program and Developmental Disabilities Administration. You have with you, I think, Andy Culp, Laura Howe, Rachel London, and Megan Berger. And you also have with you Senator, what's your name?
Craig Beidel.
Senator Zucker. So,
I thought it was a page.
Mr. Chairman, I'll be anything if they pass it.
are you going to begin, Senator?
Yeah, I am going to begin. Thank you, Madam Chair. Thank you, committee. This is a really important bill and critically important for people with disabilities. In 1999, the Supreme Court ruled in a case called Olmstead. And they basically were reaffirming aspects of the Americans with Disabilities Act. What we're doing here is really just bringing what the federal government did and said and incorporating it into our laws. And the reason that is important is because we have to send the message, and we have to constantly be sending the message, how important it is to follow the ADA, to follow the component parts, in particular as it relates to medical services and Medicaid. And with that, Madam Chair, I'm just going to pass it on because there's lots of people to say something.
Great. Thank you very much, Madam Chair. And Chair Gazzoni, thank you for your tremendous leadership, as well as the individuals on this panel. I think Senator Gazzoni, Chair Gazzoni, hit the nail on the head. Really what we're doing with this piece of legislation is putting into state statute protections that should already be afforded individuals with developmental disabilities. That's why the name of this bill is Maryland's Protecting Individuals with Disabilities Act. It also goes a little bit further in terms of data collection and making sure that the resources are being expended in an appropriate way and that they're being utilized. I do also want to thank the Department of Health, Madam Chair and colleagues. They've been working closely with us and in my office, and they were going to submit written testimony, but because there are amendments that are being offered, they want to get a full scope of both the positive impact, but also get a sense of the scope. We did send them some of the amendments, so they're reviewing it now. But this is a step in the right direction, especially given all the uncertainty out there. This is a step that helps toward protecting those with developmental disabilities. So with that, I'll turn it over to the panel.
Rachel. Good afternoon, Madam Chair, members of the committee. I'm Rachel London, the Executive Director of the Maryland Developmental Disabilities Council, a statewide policy organization led by people with developmental disabilities and their families. Maryland has a long history of moving people out of large institutions and into community-based homes, jobs, and lives where they belong. The state closed outdated and unsafe state residential centers, like the Rosewood Center, and replace them with supports in the community that respect independence and dignity. Today, over 20,000 Marylanders with developmental disabilities get services in the community, while under 100 people live in those state residential services like Holly or Potomac centers. That means well over 99% of all Marylanders with developmental disabilities live in the community, exactly where they belong. This bill helps keep it that way. It doesn't create something new, but codifies existing federal Medicaid protections to ensure timely eligibility decisions and prevent people from losing services because of paperwork or administrative delays. That's common sense. No one should be pushed back into more restrictive settings because of bureaucratic barriers. As you heard, it also advances the spirit and the promise of the Olmstead decision. This bill removes those barriers that I just spoke about. You're going to hear a lot more about momentarily that really can force people back into institutional care. Olmstead isn't just a legal principle. It's a call to action. It recognizes that when someone wants to live in the community, the state must make that possible. Senate Bill 742 helps fulfill that promise. When Maryland codifies these protections, it strengthens our ability to keep people where they belong, in their homes, with their families, and fully participating in their community. For these reasons, the council strongly supports Senate Bill 742.
Good afternoon, Chair Beidel and Vice Chair Hayes and members of this committee. My name is Andy Culp, and I'm the Executive Director of the ARC Maryland, a statewide organization dedicated to protecting and advancing the fundamental rights of people with intellectual and developmental disabilities. And we support this bill because we believe it will require the Department of Health to fix a very broken, complicated, unresponsive Medicaid and Medicaid waiver eligibility process. For 2 full years now, Marylanders with disabilities have suffered, their families have suffered, and their DDA providers have suffered due to a pervasive lack of care and accountability to ensure Marylanders with disabilities maintain their Medicaid insurance and waiver status as required by federal law. A pre-pandemic DDA and Maryland Medicaid used to work with providers and families and people with disabilities to make sure people stayed within the waiver, but all that ended in 2024. This is when we saw mass disenrollments, erroneous termination letters, terminations without any notice, and other confusion. 2 people in the room today, Isabel and her daughter Juana, who are sitting in the back of the room, recently found out they lost their Medicaid, and Juana's lost her services. Her mom has no choice but to stay home with her. Uncompensated, her mom can't work, and Juana can't go out either. So when this happens, like Juana, people are placed at imminent risk of institutionalization. If not for their providers and family members providing uncompensated care, to the detriment of their stability in their jobs, people would face harm and some may have died by now. So our luck is running out. And as this issue continues, and our situation will absolutely get worse with the implementation of H.R. 1, which mandates 6-month redeterminations of other Medicaid recipients, putting additional pressures on an already overwhelmed, understaffed Medicaid eligibility determination division. So in closing, I ask that you protect Marylanders with intellectual and developmental disabilities by ensuring compliance with federal law, as this bill would ensure, and asking Maryland to comply with its own Medicaid manual. Thank you.
Thank you. Laura, I guess.
Good afternoon. My name is Megan Berger. I'm the legal director at Disability Rights Maryland, a nonprofit law firm and the federally mandated protection and advocacy agency for Maryland. In keeping with the Olmstead Supreme Court decision, one of DRM's legal priorities is to help people access home and community-based services so that they are not institutionalized and remain in their communities. Since January 2024, people have been losing their Medicaid and waiver eligibility at alarming rates. DRM has received hundreds of calls from people who are desperate for help. The flooding of requests for legal assistance is indicative of the broken system in Maryland. This bill would help people like the following who called DRM for legal assistance. A young woman with a developmental disability who submitted her redetermination paperwork in advance of the deadline. She received confirmation from the state that it received her paperwork. However, months later, she inexplicably received a Medicaid termination notice from the state stating that her application had not been completed timely. Her mother appealed the termination in August and still has heard nothing about a hearing date. In the meantime, her services are suspended. She is without care. And it is egregious in this situation that she does not have services pending the appeal. a young man with a developmental disability who was denied home and community-based waiver services because his legal guardian's signature wasn't applied to the signature page. An older gentleman who was denied Medicaid coverage and lost services. He appealed. A month later, the state sent him another notice and requested additional financial information. 5 months later, the state sent a third notice denying him services for being over the financial asset limit. It was only after DRM's intervention that his Medicaid was approved and waiver services were reinstated, 11 months after the improper denial. The examples above illustrate just how alarming the procedural errors and massive processing delays are, and how individuals are unjustly harmed, even when the state has made the procedural error and improperly terminated Medicaid coverage. For these reasons, DRM strongly supports Senate Bill 742 and urges a favorable report.
Good afternoon, Madam Chair and members of the committee. I'm Laura Howell, the CEO of the Maryland Association of Community Services, representing over 125 community DD providers across Maryland in strong support of Senate Bill 742. Since January of 2024, people with developmental disabilities have been losing their Medicaid and DDA waiver eligibility at an alarming rate. To give you a sense of the depth of the issue, we surveyed our members, and with only 60 providers responding, and that's a portion of the over 250 providers across Maryland, almost 1,000 people with developmental disabilities had erroneous waiver disenrollment between January of 2024 and January of 2026. It's really important to note that 44% were out of the DDA waiver for more than 6 months. 39% are still not reinstated. And of those 60 providers, they are owed $36 million for services they delivered without reimbursement. And this reflects only a portion of providers statewide. When Medicaid coverage ends for this group of people with developmental disabilities, home and community-based services cannot just stop. People rely on these services for medication management, behavioral supports, 24-hour residential support, and day and employment supports. These services are vital. Community providers are forced to choose between financial solvency and the well-being of the people they support, and they often don't have a choice. They must continue to provide support to make sure that people remain safe. Even when later found eligible, some people are told they must wait for a waiver slot to open before they can be reinstated in the waiver, further delaying their access to the needed services for which they are eligible. Senate Bill 742 does not expand eligibility. It simply requires the state to comply with existing federal law and requirements. And for these reasons, we urge a favorable report. Thank you.
Thank you. That's everybody, right? Everyone's testified. Do I have any questions for this panel or the senators? I don't see any questions. You did a good job. Thank you.
Thank you.
Now we're going to bring up Matt Rice, Tracy Wright, Marlene Hendler, Ray Bailey, Chelsea Ewers. Okay. I don't think we have everybody, but
Would you mind moving over? No worries. Absolutely. Yeah. Do you want me to put this where? I'll take it. Okay, thank you. Okay.
okay. Who would like to start?
I'll start. Good afternoon, Madam Chair and members of the committee. My name is Tracy Wright, and I'm here today in strong support of this bill. I work for People in the Go Maryland statewide self-advocacy group, and I've had the privilege of working with several people as they transitioned out of Rosewood when it closed in 2009. And I got an opportunity to talk to the staff directly, who told me that when there were too many people to care for, that people actually had to be hosed off for a shower and stood in a line and just hosed off with no privacy. And one of our members, one of our people in the Go members who used to live at Rosewood also told me when he made mistakes, when he was told to do something, he was hit. And Rosewood was closed over many cases of abuse. We cannot go back. Our members, we can't. People deserve the right to live in the community, get supported in the community. There's not a person that lives in the community now or that lives in the institutions now that are still left that couldn't be supported in the community. But people that are in the community don't deserve to lose their right to live in the community of their choosing with their family and friends. And people need the opportunity to grow and develop skills, and in the institutions they cannot do that. So please protect our rights.
Thank you for your testimony. Who's next?
Let's see if I can project. For the record, my name is Matt Rice. I am the Executive Director of People on the Go Maryland, Maryland's statewide self-advocacy and systems advocacy organization run for and by those with intellectual and/or developmental disabilities. We are here in strong support of Senate Bill 742 for the reasons that have been outlined by the previous panelists, but I also wanted to highlight the fact that, you know, as a person with a developmental disability who relies on services through DDA and works and gets supports through EID, I personally fear the time when eligibility redetermination comes up, because I've gotten contradictory notices before, because Department of Social Services and eligibility determination don't talk to each other about who is eligible and who isn't under the correct criteria. So it's often on the person to make phone calls to find out why they were declared ineligible. And sometimes that takes weeks of back and forth, if not months. And right now, I'm not only advocating for myself, I'm also serving as my brother's primary caregiver who's living with me. And if I don't have the protection I need, I can't run People on the Go, but it also means that you're risking institutionalization of not only one person, but two people. So please, I strongly recommend a favorable report for this legislation. Thank you.
Matt, it's nice to see you again.
Thank you, Madam Chair.
Who's next?
I can go. Thank you, Chairwoman, Vice Chair Hayes, and members of the Finance Committee. My name is Chelsea Yours. I serve as the Director of Government Community Relations for Chimes International. I'm here today representing our local affiliate, Chimes Maryland, and the 500 individuals that we support with intellectual and developmental disabilities achieve their fullest potential. I'm testifying today in support of Bill 742, the Maryland Protecting People with Disabilities Act. Thank you, Senator Gazon and Senator Zucker, for introducing this legislation. This bill would directly impact numerous individuals with intellectual and developmental disabilities who are erroneously disenrolled and who struggle to work within a system that is perpetually ending services rather than continuing care. Currently, the state allows a 90-day time period for an individual to appeal their loss of services, and I'm here today alongside providers and individuals receiving services to tell you that this system is not working. The state needs to repeal the 90-day limit and follow existing federal law to keep people in the waiver. Far too many individuals are being kicked out of waivers regardless of how much time and energy the individual, their support staff, and providers like Chimes spend to try and get them re-enrolled, and are still being denied in some cases for multiple years. I tell you honestly today that providers like Chimes cannot and will not let these individuals fall through the cracks. I have with me today 8 pages of documentation from just one case of an individual who was disenrolled from services. Over the course of nearly 5 years, our staff tried to get him back into the waiver.
He's 39 years of age and has been in community living with Chimes since 2017 after facing an eviction. He's also receiving employment services and moved from a person-centered plan to the waiver at the end of 2020. In less than a year, he was disenrolled and was not reinstated until October of 2025, only to fall back out of the waiver at the end of January of this year. The documentation I have with me shows every attempt our staff made to send, resend, follow up, and confirm information that EDD in this gentleman's case had for well over a year and either lost or had not applied to his case, leaving my staff who need to be spending their time providing direct support instead gathering and resending support documentation. I thank you for your support of this legislation in the disability community.
Thank you.
Good afternoon, Madam Chair and members of the Senate Committee. My name is Ray Bailey. I am a single mother of 2 adult sons, Patrick and Naeem. While my testimony today centers on Naeem, who receives services through Maryland's Developmental Disabilities Administration, DDA, both of my sons are deeply impacted by the systems that support individuals with disabilities and their families. For families like mine, DDA services are not optional enhancements. They are essential. They provide stability, they provide safety, they provide structure, and the opportunity for individuals with disabilities to live with dignity and meaningful inclusion in their communities, and that's what we need. Naeem, he relies on these services to access the support he needs to thrive. These supports do not just affect him as the individual. They directly impact our entire family's ability to function, to work, and to plan for the future, and to maintain any stability we already have. When DDA services are strong, families are stronger. When they are uncertain or underfunded, the entire community suffers. Direct support professionals and service providers are the backbone to this system. They perform highly skilled, deeply human work. Reductions that affect compensation or stability within this workforce do not exist on paper alone. They translate into turnover, disruption. It also means disruption of trusted relationships, like you've heard from these individuals, and instability for individuals who depend on consistency. For families navigating disability service, consistency is not a luxury. I am here not as a mom, but as a part, not only as a mother, but as a part of a broader Maryland community that relies. I hope you vote favorably.
Thank you. Hello, Madam Chair and Vice Chair Hayes, and other members of the Senate Finance Committee. I'm here to support SB 742. Excuse me, I'm not wearing my glasses because they're broken, so bear with me. So that I can get relief from the constant fight I've had maintaining my medical assistance benefits. I developed cerebral palsy as a 2-month-old premature baby with an umbilical cord wrapped around my neck. Cerebral palsy is a central nerve and muscle disorder that is caused by lack of oxygen to the brain. I was diagnosed with CP at 3 days old. I want to repeat 3 days old because my testimony has one main point. I've been permanently disabled all of my life, yet the system makes me fight for my medical assistance and life care benefits over and over again. And I'm in the midst of Medicaid recertification now as we speak. You have heard the main changes this bill makes to stop Marylanders with Medicaid coverage from being suddenly thrown off the enrollment. Enrollment in medical assistance actually keeps people with disabilities alive. Let me tell you a few important ways I use medical assistance and what will happen if Maryland cuts off my medical assistance benefits. Here are the services I depend on through medical assistance. First, I receive home-based services under the Community First Choice program. If I lose my Medicaid, I lose the first choice, the Community First Choice program. My support planner, who I get through Service Coordination Incorporated, helped me get services and has devoted hours dealing with, I'm also fighting over my mortgage at this time, that's why this was put in there, so I can stay in my home in Columbia. I have a service coordinator who's also through Service Coordination Incorporated.
Can you please finish?
There's a
your
little
comment?
bit more.
Okay.
Okay. Together, these staff people help me lead an independent life. I also get medical and technical equipment that allows me to communicate, hold a job, and monitor my treatment. My transportation benefit is essential. It helps me get to my appointments that are early in the morning. I can't use paratransit when I have very early in the morning appointments. I have to use medical assistance transportation, and if I lose CMA, I lose that. If my benefits are cut off, even for a short time, I will suffer. First, I would have to pay monthly Medicare premium plus 20% of all my medical services. I have a job, but there's no way I could afford that. Almost no Marylanders with medical assistance since birth could pay those bills. Second, I would lose my transportation and equipment. I need to hold down my job and work for my church and any advocate and an advocate for the disability community. Last, I would lose my home-based support planner and service coordinator who deal with the paperwork and bureaucracy so I can live independently. It's hard for me to write by hand, so these people help me do all the paperwork that needs to be turned in for me to keep my services. And for us to be certified for these services, it takes a lot of time and a lot of effort. I spent 3 hours in a meeting yesterday dealing with paperwork and another hour before I came here, so there's a lot of time.
I really
that's put
thank you
into
for your
this.
testimony, but we still have 8 people on this bill, so if you can finish your sentence, we're going to move on to the next 4.
My friends help me so I don't have, when my health aid is not available. But every day I worry about keeping my medical assistance and staying in my home. In closing, I want to thank Senator Gazone, who represents my district, has heard a lot from me and other Marylanders with disabilities like me need. Please pass Senate Bill 742 out of the Finance Committee and bring it to a vote. The disability community of Maryland is counting on you to protect our access to medical assistance.
Thank you. We have a question from Senator Crank.
Thank you, Madam Chair. I just wanted to say thank you to all of you for being here today, taking the time and the trouble to share your experiences so that we have a thorough understanding of the issues that you're dealing with. So thank you for that. Thank you, Madam Chair.
Thank you, Senator. Okay, so this panel is complete. I see no other questions. We're going to have David Wamsley, Daphne Steffen, Christina Moore, and Chip Woods come up. Got a little traffic jam up there. Yeah. Okay, who would like to begin? Okay, you can start.
Good afternoon, Madam Chair, Mr. Vice Chair. Thank you for this opportunity. I'm David Wamsley.
Pull the microphone over. Just, it'll stretch. There
I'm
we
the
go.
Executive Director of Emerge. I'm here with my wife, 50 years, and the Deputy Executive Director's in the back. We're a little crowded, so we'll go forth. In short, I'm both an Executive Director, but I'm also a caregiver because my wife actually worked in this field 20 years, or she worked in the field for 20 years. 10 years in, she developed MS. Ultimately had to retire. At this point, I'm able to take care of her at home. How long I can do that, we will see. Hopefully forever. But we both live this and I work it. I run Emerge Incorporated. We serve about 300 people roughly. About 10% of the people we serve right now are out of the waiver. They've been out of the waiver. The state owes us about $4 million. We have not discharged anyone because we have a board of directors that is absolutely committed. So we're using reserves. We do fundraising. Some of this we may get back, some of it we won't. We're okay with that up to a point, but we cannot do $4 million a year over the next 10 years. Having done this since 1980, we're in rough shape right now. And unfortunately, we believe in working with people, so Emerge would send our staff down to EDD, talk to them, hey, what's going on? What do you need? And they're going to go back down the next day. Unfortunately, EDD has now cut that off. Probably trying to get things straight, but we can't communicate. And it's going to be with this bill, if you pass this bill, it's going to make it so tight that we can get back to that cooperative relationship that we need. So I will end my time. Thank you.
Thank you, Mr. Wamsley. Who's next?
I can go next. Just before my time starts, if I could, Madam Chair, I have a parent with me that I'd like to yield my time to, if I could say a few. You don't? Okay. 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 My name is Chip Woods, and I serve as the executive director for St. Peter's Adult Learning Center. We're in the 40th district, and we are a DDA provider since 1982. A lot of the points that have been heard since January of 2024, people have been losing their Medicaid, and even when they reapply, some are being told they need to wait for a slot to open up before they can have their services again. It also affects providers, as has been mentioned, with the cost of, we have to have to cover the cost when Medicaid has been canceled. And it also affects the families as well. What will this bill do? Two very important points that I found. That Maryland cannot end a person's Medicaid when it does not do its part to keep the person continuously enrolled. Also, Senate Bill 742, Maryland must reinstate a person's eligibility if they were disenrolled for certain reasons. We are very fortunate to have this opportunity. I thank you for the opportunity to share that. But more importantly, the folks that choose St. Peter's as their provider of choice. We try to do the best we can, but if we urge you to, and this committee, to support this bill and solve these issues that you've heard today. Thank you so much for your time.
Thank you, Mr. Woods. Who's next?
Good afternoon, Madam Chair and members of the committee. My name is Daphne Steffen, Chief Operating Officer of Opportunities, Inc., supporting nearly 300 adults with intellectual and developmental disabilities across Maryland in their meaningful day in employment services. I am here in strong support of Senate Bill 742. Every week, I log into our billing system to see whose Medicaid payment has been kicked back. And every week, we face the possibility of pausing essential services, not because someone became ineligible, not because their needs changed, but because of avoidable breakdowns in eligibility redetermination. Since late 2024, we have had to pause services for 16 people. Today, 9 still remain without services. some for months, some even more than a year. These gaps are devastating. When eligibility is wrongly terminated, services stop immediately. People become isolated. Families are forced to leave work to fill the gaps. What should be a stable support system becomes a crisis overnight. Providers feel this too. In a fee-for-service model, if we cannot provide services, we cannot bill. Revenue stops instantly, but the costs do not. We still have staff, infrastructure, and fixed expenses to maintain. These interruptions create serious financial instability for community providers already operating on thin margins. We never want to stop services. These supports are what allow people to work, build relationships, and live meaningful lives. But we cannot continue delivering unfunded services in the environment that we are in. This bill creates the accountability and system coordination that Maryland urgently needs and protects continuity of care and stability for people with disabilities, their families, and the providers who support them. Thank you.
Thank you. And finally, Christina.
Madam Chair, Vice Chair, and other members of the Finance Committee. My name is Christina Moore. I participated on the task force on countering and preventing elder abuse. I'm also the chief attorney of the Administrative Law Unit in Baltimore City at Maryland Legal Aid, a nonprofit law firm that provides free civil legal services to low-income and vulnerable Marylanders, including people with disabilities who are able to live in the community because home and community-based services provide the supports that make doing so possible. Thank you for the opportunity to testify in strong support of Senate Bill 742, which addresses real and urgent barriers that our clients face. Currently, eligible applicants for home and community-based services are stuck in nursing homes simply because the state has not timely processed their applications. While they wait, they may have to pay both their share of nursing home costs and their rents or mortgage, which creates an impossible choice that can cost them their housing and make returning to the community harder and more expensive. In my written testimony, I told you about Miss M and PG who face the exact same very real choice. And people living in the community can be left in unsafe situations as they sit on wait lists despite having serious medical needs because of administrative delays. In my written testimony, I told you about Ms. K from Baltimore City, who has been without medically needy services for around 1.5 years, and about Ms. C in Baltimore County, who relies on the home and community-based options waiver to subsidize her care in an assisted living facility. As you've heard, when services are interrupted, the consequences are immediate and devastating, including the loss of caregivers, health deterioration, preventable hospitalizations, and unnecessary institutionalization. SB 742 offers practical, targeted solutions. It requires the state to use existing data before cutting off services for missing paperwork, and it prevents gaps in coverage by ensuring continued services while eligibility issues and appeals are fully resolved. It also allows automatic reinstatement and retroactive coverage when loss of services is due to agency delay or error. For these reasons, Maryland Legal Aid strongly urges a favorable report on this bill.
Thank you. Do I have any questions for this panel? Seeing no questions, we're going to go to our virtual witnesses. Thank you all for your testimony. So I think I have, is it Joanna Weaver? Joanna Weaver. Joanna, you unmute and give us your testimony, please.
Yes, my name is Joanna Weaver, and if you'll excuse me, I'm going to mute my phone. I'm happy to testify today on support of Bill 742. I live in Wycomico County, and I'm getting ready to self-direct my services. And I have to say that I am terrified. I am terrified because while leaving the agency that I'm with, because they cannot manage my care, I am going into self-directed services, and for the past 2 years, I have been temporarily kicked off of Medicaid. It can be as much as 3 months or 4 months before I am allowed back on, and it is simply because of paperwork delays. While I'm self-directing, I am the one responsible for paying my staff. I am the one responsible for making sure that my services get done correctly. This could open me up to lawsuits. It could open me up to lack of services for months at a time, which could cause pressure sores and other health issues that can become extremely dangerous. I am asking for support of Bill 742 because it will give me and others in my situation some relief to be able to manage our services effectively. If you can imagine what it would be like to have to lay off my staff at least once a year because the paperwork is delayed for my Medicaid, what it would be like to have to constantly replace staff. Thank you very much for hearing my testimony today.
Thank you, Joanna. Next, I think we have Lillian Molell. Lillian? You want to unmute?
Hey, hello. My name is Lillian Molell, testifying for SB 0742. My son, Julius Ricketts, is 23 years old, and he's profoundly autistic and requires round-the-clock one-on-one support with daily living. For Julius to access the community, he needs line-of-sight attention. But due to his intensive need for support, Julius was determined by DDA to be eligible for Medicaid waiver, and he was approved to receive enhanced support waiver since 2023. And the waiver provided staffing, behavioral support, and also nursing support for medication regimen monitoring. The waiver helped tremendously with his everyday needs, such as life skills, communication skills, independence, safety, as well as the opportunity to interact with his community daily. He would go out with staff to various activities such as swimming, table tennis, meeting with friends, long walks in the neighborhood trails and parks. The waiver also provided me with the support to be able to take him to the doctor's office and to various therapies to help to stabilize him and treat his condition. And none of these are now possible without the waiver. I cannot manage alone. Julius is 6 feet tall and weighs 325 pounds, and I can't take him anywhere alone safely without a staff member with us. This means he's virtually trapped like a prisoner in his own house. It was very shocking to learn that his waiver was dropped even after we submitted all of the required documentation for redetermination on time, and we didn't miss the deadline. Deadline was January 31st. We submitted documentation January 8th by email and by physical mail. And then our determination submission were not acknowledged until February 13, well after the deadline. And Julius was disenrolled from the Medicaid waiver. Hello?
We can still hear you, but your time is up. If you could just finish your
Okay.
sentence, please. Thank you.
All right. So he was disenrolled, and there was no explanation given, and that's why we're strongly supporting this bill.
Thank you for your testimony. Amanda Lay? Amanda, you need to unmute. Can you unmute? I don't know what to do. Amanda, there you go. Thank you.
Good afternoon, committee members and guests. I am pleased to testify in support of SB 742. My name is Amanda Lay. I'm from Rockville, Maryland in Montgomery County. At the age of 9 months old, I was diagnosed with quadrispastic cerebral palsy. I need total support with every physical aspect of my life. I can't feed myself. I can't dress myself. I can't brush myself, my teeth or my hair. every physical aspect of my life, somebody else has to support me in as a result of my being born with cerebral palsy. And I'm here today to ask you to recategorize things so that I don't have to recertify in order to get services, to say, yes, every year I do still have cerebral palsy. It is demeaning and hurtful, and people with permanent disabilities should not have to go through endless amounts of paperwork to verify that they do still have a disability. It costs the state money, it costs my staff time, it's laborious and unnecessary, and people with permanent disabilities should be in a separate category. It's hurtful to say that we still have a disability. The system is broken and failing and has enough obstacles without putting another one that we have to jump through. And I appreciate your consideration and your time and your support of this bill. Please support SB 742. Thank you.
Thank you very much, Amanda. Do I have any questions for Amanda? I think the other folks came off virtual. And I just need to check if Robert Burkhart's there. We don't believe he is. Okay. Thank you very much for your testimony. I see no questions. That ends the hearing on Senate Bill 742. I see that Chair Feldman is here for Senate Bill 778. Clinical research pharmacies and clinical trials. Senator Feldman, you have Alan Freeman, Kelly Schultz, and
Kelly
Andrew Zirkle
Schultz
with
as
you.
well. Thank you. Madam Chair, so just if you indulge me to kind of lay out Senate Bill 778 for a couple of minutes here. You know, we've had the last few years a lot of reports about Maryland's stagnant economy and the fact that we're not producing enough private sector jobs, anti-business branding. And I'm going to be bringing some bills today, tomorrow, one today, one tomorrow, dealing with, well, designed to address that issue. So these are pro-business, pro-innovation economy, pro-private sector job growth, which is why we've got Kelly Schultz from the Tech Council here in support. You'll see a letter of support from the Maryland Chamber of Commerce as well. And this bill deals with medical clinical trials, which do represent a significant economic driver for those states that can successfully attract them. And so here we're living in a state where we've got NIH, we've got FDA consolidated headquarters, University of Maryland Medical Center, and we should definitely be a leader in this lane. And Maryland currently does have a meaningful but relatively small share of the national clinical trial activity. According to a 2023 study from Pharma, Maryland has 936 active clinical trials involving an estimated 18,000 participants. The biopharmaceutical industry invested about $658 million in direct site-based expenditures in Maryland. But the reality is, while Maryland does benefit from the presence of all these world-class research institutions, the state's industry-sponsored clinical trial activity represents, Madam Chair, only 2% of the national trial participants and 2.1% of direct site-based investments. So in short, Madam Chair, members of the committee, Maryland is leaving a lot of money on the table in this space, particularly relative to Virginia, right over the river. And the regulatory framework currently in place here is one of the causes, which I'll discuss in a minute. So Senate Bill 778 is designed to remove barriers to clinical trial site development. And I hope the committee will indulge me for another minute or two just as I describe the bill. So what it does is it establishes a new, very narrow licensure category for clinical research pharmacies, a clinical research pharmacy permit that allows authorized healthcare providers to hold ownership interests in clinical research pharmacies under very, very specific safeguards. Now, we currently have restrictions on physician ownership of pharmacies, which is a very important protection for our Marylanders. A public health purpose, again, we're talking about retail pharmacy context. For that context, in those situations, these restrictions on ownership are very, very important. When physicians have a financial interest in retail pharmacies, they have total discretion on how much is to subscribe. Nobody's looking over their shoulders. They may face perverse incentives to prescribe medications unnecessarily or in excessive quantities, favor more expensive branded drugs over generic alternatives, direct patients to their affiliated pharmacies rather than allowing patient choice, or otherwise allow profit motives to influence clinical judgment. Those concerns are well-founded and justified, continue to maintain strict restrictions on physician ownership of retail pharmacies makes 100% sense. However, these same concerns are not present in the limited scope and context of clinical trial, clinical research pharmacies, which are governed by very strict federal regulatory oversight, protocols governing amounts, enrollment, designed to protect patients and prevent abusive clinician behaviors. The panel, Mr. Freeman to my left, will elaborate on that. But if you violate those protocols, your studies can get thrown out or shut down. A lot of disincentives to not follow all the federal rules. So to get a robust clinical trial activity here in our state beyond this really pretty lame, to be honest with you, 2% number I cited earlier, we've got to incentivize both physicians and pharmacists. We need physicians who specialize in treating complicated diseases and biological disorders, as they're the ones who provide important input, possess unique insights into the patient populations, disease progression, therapeutic needs, et cetera. On-site research pharmacies are also required, as the pharmacists know how to manage investigational drugs, ensure compliance with all the various federal review boards, approved protocols, and standards. So what we've done here in this bill is it recognizes there is a huge difference between retail pharmacies and clinical research pharmacies by specifically identifying and limiting these new clinical research pharmacy permits to facilities that do the following. They exclusively are dealing with compound, dispense, or distribute prescription drugs as part of scientific research. They're limited to dispensing pharmaceuticals solely associated to the research being conducted and consistent with related protocols, are not open to the general public for retail pharmaceutical services, strictly limited dispensing to clinical trial participants, comply with security and storage protocols. They eliminate any kind of anti-kickback concerns that justify the restrictions we have on ownership when it comes to retail pharmacy ownership. They cannot write prescriptions for personal benefit, and a whole number of things that are laid out in the bill, and my panel may elaborate. Again, additional safeguards that prohibit physician owners from directing patients to a single pharmacy or pharmacist, and on and on and on. And so, I just want to make the point in sum, and then again, I'll take questions. Senate Bill 778 represents a very measured, evidence-based approach by removing unnecessary and burdensome barriers to clinical trial site development in Maryland, spurring economic investment in limited purpose clinical trial site activity, which is a high-impact industry sector, while maintaining strong patient regulatory protections and safeguards against fraud and abuse. By precluding physicians from holding a substantial ownership in these clinical research pharmacies in Maryland, it discourages those who are best positioned to advance medical research in our state and from establishing and engaging as owners of clinical trial facilities in the state. So that's in a nutshell. Now, there are two letters that have come in that I have taken a look at, and I will, if you don't mind, Madam Chair, I'll respond to. There's a letter of information from the Board of Physicians, not a letter of opposition, that they have an issue with changes made to the definition of practice of medicine. And I think Mr. Freeman will speak to that. Clinical research is widely understood throughout the rest of the United States and across the country as falling outside the practice of medicine because it does not involve diagnosis, treatment, or the prescription of medicine. The investigators who are involved in these trials have to be in compliance with a myriad of strict FDI protocols and guidelines. They are not engaging in any kind of general practice of medicine outside the very narrow scope of the registered clinical trial. And there's a whole bunch of other qualifiers, not even close to this concept of practicing medicine in any traditional sense. That said, I do believe there's a opportunity to get a compromise amendment in place with the Board of Physicians to get them this definition of what's a practice of medicine. The other letter I'll address, and then I'll be done, it has to do with the Board of Pharmacy, a letter of opposition. And we did have a meeting yesterday with the board, and I'll make this point, and there were some things that we discussed yesterday that I don't believe they were fully aware of, but it's based, I think, if you look at their letter of opposition, based on the same ownership concerns that exist with retail pharmacies. And these restrictions are completely justified in the retail pharmacy context, but applying those same arguments, as I mentioned earlier, to the clinical trial pharmacy seems to reflect, again, a basic understanding of the difference. So, number one, the board letter does not take into account the fact that clinical trial protocols define every aspect of the trial process, everything from informed consent to dosing to data capture and adverse event reporting. Unlike a medical office, the investigator's discretion is tightly controlled and limited. They are designed to prevent the very concerns raised by the board in their letter. Secondly, the board letter also ignores several layers of federal oversight that closely monitor the entire clinical trial process. Even before a single patient is enrolled, there's a review board, must review and approve the entire process, ensuring, among other things, that the very concerns raised by the pharmacy board are fully and satisfactorily addressed. And as I mentioned earlier, other states, including Virginia, do not clearly see things very differently. And then finally, Madam Chair, I mentioned earlier that the disincentives to do anything outside the realm of federal review are there, because if you do anything outside the purview of what's required, you can get shut down or your study shut down, and that doesn't make any sense. So again, I think this, based on the meeting we had yesterday with the board of the pharmacy board, I also think there's a decent shot that we can come up with a middle ground so that we can bring this into the state of Maryland, bolster our economy, and not lose out to some of the states around us and around the country that are actually very much involved beyond this 2% number that we're stuck at. So, Madam Chair, I'll let maybe the witnesses, if you don't mind, weigh in, and then I'll certainly take some questions.
It's fine, Senator. Thank you.
Okay, good afternoon. My name is Alan Freeman, and I'm the General Counsel of a rare disease clinical trial company based in Montgomery County. By permitting expanded physician ownership of clinical research pharmacies and by clarifying that clinical trial sites need not be owned by physicians, this bill would remove unnecessary barriers to clinical trial site development, spurring economic growth and expanding access to clinical trials while maintaining robust participant protections and safeguards against fraud and abuse. Current law wisely limits ownership of retail pharmacies in order to prevent physicians from profiting inappropriately from their prescribing practices. But that concern does not apply in the clinical research context, where physician investigators do not prescribe drugs, and their discretion over trial activities, such as enrollment, dosing, and dispensing, is strictly limited by federal oversight designed to protect participants. Before a trial enrolls a single person, an institutional review board must evaluate the study protocol, the informed consent documents, investigator qualifications, facilities, and potential risks to participants. The IRB must determine whether the protocol and site employ guardrails to protect against potential conflicts of interest, whether arising with the investigator, the pharmacy, or the owner of the site, and these reviews continue during the trial. The rigid structure of clinical trial protocols, coupled with layers of federally regulated oversight, mean that the physician owner's financial interest could not meaningfully influence study conduct. In fact, the overwhelming incentive is to ensure strict compliance with the protocol, because any deviation could result in disqualification of the investigator, rejection of the study data, and significant personal liability, consequences that far outweigh any theoretical short-term financial benefit from a deliberate deviation. This bill would retain the pharmacy board's jurisdiction and also clarify that physician owners are allowed but must be segregated from decision-making related to trial execution. The bill would strengthen our clinical research infrastructure, create high-quality jobs, and improve access to cutting-edge treatments for Marylanders across the state.
Madam Chair, members of the committee, for the record, my name is Kelly Schultz, and I'm the CEO of the Maryland Tech Council. And I'll just start by saying, wow, what a crazy year and a half we've had in the life science world. Just to set the stage, Maryland is, as you know, I tell you frequently, the third largest biotech ecosystem in the country, right behind California in Boston. What the chair of a different but equal committee, Madam Chair, is bringing today is to talk about not only keeping us in that number 3 spot to be able to create additional jobs, have additional workforce, and create a better environment ecosystem for biotech, but also to be able to create a better environment for the patients. Right. So what we're talking about here is clinical trials in some with rare diseases like we have just talked about. But we also want to talk about all of those opportunities that people in Maryland, that 2% that we have only in Maryland for clinical trials. There's a lot of things that Maryland leads in. This is not one of them. And in order to be able to create that economic development strategy where we talk about healthcare specifically and the life science ecosystem broadly, is to be able to bring all of those different parts to us. And what we've experienced over the past year is some decrease in that because of what has happened at the federal level and having reductions in research dollars at NCI and NIH and FDA. And this is really a way in order to be able to keep the talent that we have here in Maryland in a different capacity, talking about clinical trials, creating jobs, but also creating diagnoses, treatments, and solutions for other Marylanders that they may not currently have. We are here in strong support of this bill.
Thank you, Madam Secretary. Do other states do this? Are other states already allowing this?
I'll let Mr. Freeman answer that. I do know that we're looking at Virginia, to be honest with you. That's a very much, so the prohibitions and barriers that are addressed here do not exist across the river in Virginia. So that I know about Virginia. Mr. Freeman has more of a national perspective on this.
You want to answer?
Yeah, so the interesting thing, this is a negative, not a positive, right? Currently, Maryland prohibits what is defined as substantial ownership, and the pharmacy boards interpreted that as more than 10%. I'm not aware of other states that have a similar prohibition. That's not to say that there isn't one. What I do know, and with the caveat that I'm a Maryland lawyer, not a Virginia lawyer, is that according to the Virginia statutes, a physician may be an owner of a pharmacy provided that there is a pharmacist in charge who is in fact the permit holder. So Virginia, by structuring its law that way, allows substantial physician ownership, whereas Maryland does not.
Senator Ellis.
Yeah, thank you, Madam Chair, and thank you, Mr. Chairman, for this bill. Last fall, went on a tour of the AstraZeneca facility in Montgomery County. Really amazing, impressed. Ms. Schultz, you were there. Quick question for you. You mentioned that Maryland is number 3 in the biotech space. Do you see a day where we can become number 1 in the country?
Listen, I am the ultimate optimist. Being number 1 is always a great goal. Surpassing the number of companies that Boston has or Southern California. Geographically, Maryland is a smaller state. What I see as Maryland being number 1 is some very specific things. And Maryland is, leading the pack in things like CAR-T. Right, and different types of diagnoses, and CDMOs and manufacturing, and there's different parts. I think what Maryland is missing is more of a full package, and this clinical trial initiative is one of those parts that will keep us to where we are. I will say there's a risk of us losing the number 3 as opposed to going to the number 2 or the number 1 because of various items. But this is a way in order to be able to keep the jobs here, to keep our industries here, to hold tight onto that sector that we cherish.
Yeah, what type of, I'm sorry.
Could I just wait just very quickly? I don't think a lot of folks fully appreciate what we have in terms of federal assets here in that lane, specifically with having NIH in the middle of Montgomery County, FDA consolidated. The biggest recipient of biomedical grant money out of NIH is where? Johns Hopkins University. They get more than MIT, more than Stanford. That's right here in the state of Maryland. And so, you know, number 3 is one thing. I'm talking about this bill's dealing with the 2% on the clinical trial stuff, which is embarrassing, and that's what this bill's really designed to address.
Okay, well, thank you. Thank you, Madam Chair.
Thank you. Senator Mouth?
Thank you, Madam Chair. And I was just going through some of the, there's a couple unfavorable testimonies, and they were referenced. And I was going to read a couple of the points from one of them and give you a chance to respond, just so we can get that on the record. It goes, while supporting clinical research and innovation in Maryland is important, this legislation represents an unnecessary and risky expansion of pharmacy scope that could undermine physician-led patient care. The practice of medicine, including decisions about investigational treatments and clinical trials, should remain under the direct supervision of qualified physicians who can fully assess patient risks, eligibility, informed consent, and overall health needs. I don't want to paraphrase the rest, but I think you get the gist of what the allegation is.
Are you talking about the pharmacy board letter? That's from the pharmacy board. Well, okay, I think I get the gist.
Yeah, how would you respond to that? It's suggesting that this is a risky proposal. And,
right.
And
a risky proposal that, you know, in other states don't seem risky. But let me, okay, I'll answer. In the context of a retail pharmacy, having protections against, you know, a pharmacist doing what I think I said, prescribing in a way that is in his financial interest, simply does not apply in the clinical trial setting because you're dealing with federal protocols. In other words, you're under tight, strict rules that it's like different worlds. And so I think they're conflating that somehow the concerns which are legitimate in the pharmacy, the retail pharmacy space, is somehow akin to the clinical trial space where you have federal protocol standards. There's nothing the investigators can do without running afoul or running risk of having the study thrown out, shut down. And so that's why I think Mr. Freeman alluded to is there's no financial incentive to do anything but follow all the strict protocols for clinical trials. And if you don't do that, that's definitely not in your economic self-interest to do so. So I read the words, but it's taking two models that have almost nothing in common and conflating them in a way that I think doesn't make a lot of sense. But that would be my response. I'd certainly.
Thank you.
Thank you, Senator. I don't see any other questions. That ends the hearing on Senate Bill 778.
I wish Senator Hershey would have heard this pro-business, pro-job growth, bringing, you know.
I'm sure he's going to go back and listen to it later.
Correct.
I'll be happy to remind you.
Yeah, Kelly Schultz will give you exact summary.
Senator, thank you for your visit to Finance. Next, we have Senator Shelley Hedelman. She's going to bring Senate Bill 806, Joint Audit and Evaluation Committee. And are you bringing you have a panel? Deborah Carty, Marie Savage, Laurie Kendall Ellis, Tiffany Smith Williams, and Charlotte Hoffman.
Oh, okay.
You don't have to, but
that's fine.
They're all favorable.
That's fine. Yes.
Okay.
As many as we can fit up here, we will go for. Thank you very much, Madam Chair. I'm Shelley Hedelman, Senator from District 11, here to present Senate Bill 806 on behalf of the Joint Audit and Evaluation Committee. I'm going to apologize because I'm going to leave after I give my testimony because I have another joint audit bill in B&T, right, that they moved up. So this bill, Senate Bill 806, has the distinction of trying to get all of our health occupations boards to ensure that they have a standardized system of criminal history backgrounds check. As you may recall, in the fall, there was an audit done of the Maryland Department of Health Regulatory Services, which oversees the state's health professional boards and commissions. There are 22 of them. These include the Board of Nursing, the Board of Physicians, and many others. And the recent audit report determined that many of those boards do not require criminal background checks for those applying for licenses, and some boards did not do,
and did not receive subsequent alerts of criminal activity for approved licenses. So this legislation addresses those gaps by granting statutory authority to those boards and commissions as follows. 7 boards needed initial criminal background checks and also needed subsequent alerts of criminal activity. They are for the boards of acupuncture, dental examiners, dietetic practice, nursing, forensic nurse examiners, and workers' compensation case managers, optometry, pharmacy, and environmental health specialists. 5 boards needed the instant alerts of subsequent criminal activity only. These are instant alerts via the FBI's Wrap-Back program, which automatically sends subsequent alerts of criminal activity for individuals who are already licensed. And those 5 boards are morticians and funeral directors, physical therapy examiners, podiatric medical examiners, board of psychologists, and the residential child care program professionals. This bill covers all of the boards and commissions' statutory needs that were noted by the audit and grants them the authority needed to ensure comprehensive background checks across each. And I want to say a special thank you to Nathan. This is a thick bill. I'm sure it was tedious drafting it, but just really appreciate his efforts in getting all of this right. And I think this goes a long way towards ensuring appropriate licensure and safety of everybody who's licensed under these boards and commissions. So thank you very much.
Thank you. Sounds like a really good bill, Senator.
Thank you.
You have, I guess, some folks from the joint audit?
I do, from
OLA.
From the OLA. Yep.
Can I just say one thing?
Yes, absolutely.
Thank you very much, Madam Chair. And Chair of the Joint Audit Committee, I just wanted to thank you very much for the work that you and your committee have been doing. And you had quite a busy interim with a number of reports, and we appreciate getting, seeing some potential solutions that are much needed. I think a lot of us have, been out and talking about accountability this year, and it is good to see these types of things come up before the committee. So before you left, I wanted to just make sure to say thank you.
I appreciate that. Thank you very much.
Thank you, Madam Chair.
So you're going now?
I think I'm going to go back because
Okay.
they moved me because the Secretary of DBM is there and wanted to testify on the bill.
It's all favorables. There's one favorable with an amendment, which is fine. So, and I know Nathan did a really good job drafting it. Thank you.
Thank you.
Thank you. So we have people from the Joint Audit Committee or OLA?
Yes.
Yeah, thank you. Go ahead.
Good afternoon, Madam Chairwoman. For the record, my name is Eddie Rubenstein, and I'm a director at the Office of Legislative Audits. I'll keep my remarks brief because I think Senator Heddleman succinctly summarized what this bill is about. I'm here today not to speak either for or against the bill, but just to provide a little bit more context. As the Senator said, our April 2025 audit found that certain health professional boards did not require criminal background checks, and others did not require subsequent alerts. To highlight why this is significant, during that audit, we performed a match between individuals licensed by 2 boards that did not require those background checks, Board of Dental Examiners and the Board of Pharmacy, people who were licensed as of February 2024, to conviction records from Public Safety. We identified 16 licensed dental professionals and 14 licensed pharmacy professionals who had been convicted of a crime. For example, 2 dental professionals were convicted of assault, which should have resulted in their licenses being suspended for at least a year. So, thank you.
Well, thank you for your work.
Yeah.
It's good information. Do I have any questions for the auditor? Okay, thank you very much.
Thank you.
I guess Deborah Carty?
Yes.
Deborah, would you like to start?
Thank you very much,
Uh-huh.
Madam Chair Vidal, and distinguished members of the Senate Finance Committee. My name is Deborah Carty, and I'm an appointed member of the Maryland State Board of Dental Examiners. I'm testifying today in support of Senate Bill 806 on behalf of the Maryland State Board of Dental Examiners. The board its primary responsibility is to protect the health, safety, and welfare of its citizens. Criminal background record checks are an important component of that responsibility. Unfortunately, not all health occupations, the dental board being one of them, does not require a criminal history background check at initial licensure. Others do not receive ongoing notifications of arrests, prosecutions, and wrap back, and the board being one of those. We thank the Office of Legislative Audits for bringing this to our attention. The Dental Board has no statutory authority to conduct criminal history background checks. Without consistent background checks and ongoing monitoring, boards may lack the timely information necessary to take appropriate disciplinary action. Senate Bill 806 creates a more uniform and consistent framework across health occupation boards. It strengthens public protection, promotes accountability, and ensures that all licensed health professionals are held to the same standard of oversight. For these reasons, the Maryland Board of Dental Examiners, along with the supporting boards, respectfully request a favorable report on Senate Bill 806. Thank you for your time and consideration.
Thank you very much, Deborah. Is Marie Savage here? Marie? Thank you.
Thank you. Marie Savage, I'm the director of the Maryland Board of Dietetic Practice, here in support of Senate Bill 806. The board currently does not have criminal background authority, so we're here in support of it, and I'm here to answer any questions you may have.
Thank you very much. Laurie Kendall Ellis.
Yes, thank you, committee. And first, I'd like to thank the JAEC for sponsoring this bill for us. I'm Laurie Kendall Ellis. I'm the Executive Director for the State Board of Physical Therapy Examiners. And on behalf of the board, I am here to express our strong support of Senate Bill 806. This legislation is important for enhancing both public safety and operational efficiency within the Maryland Health Occupation Boards. Senate Bill 806 has two fundamental objectives that address the policy issue noted in Finding 5 of the April 2025 audit report. First, the initial criminal history records check. Although the Board of Physical Therapy Examiners has had this for many years, this amendment is important because it establishes a uniform criminal history check process through CJIS, aligning statutory requirements for all health occupation boards. The phase-in periods ensure the successful operational implementation of this amended statute. The post-initial criminal history record check allows for, with statutory amendment, the Board of Physical Therapy Examiners to receive continuous updates of an individual's criminal history subsequent to the initial criminal history record check. CJIS will serve as a single primary source for all initial and revised criminal history record information, providing updates that get reported to them directly to the health occupation boards and to the individual as new information is reported. The ability to access criminal history record information is paramount in protecting the public. These statutory amendments are necessary to provide the consistency and operational framework required to uphold public trust. The Board of Physical Therapy Examiners and myself appreciate your time and consideration and respectfully request you support advancing Senate Bill 806.
Thank you very much. Tiffany Smith-Williams.
Good afternoon, Chair Bidle, co-chair, and the members of the committee. I am Tiffany Smith-Williams, the Executive Director for the Maryland State Board of Acupuncture. I am here in support of Senate Bill 806, which implements mandatory criminal background checks with periodic follow-up reports for all licensed acupuncturists. The decision fully aligns with all health occupation boards' missions of public protection. Access to standardized screening tools strengthens the board's ability to serve the public and to support health professionals who are in need of second chances to be able to continue to practice and to practice well. I strongly urge moving forward with the bill, and I'm here to answer any questions that you may have. Thank you.
Thank you for your testimony. And we have Charlotte Huffman, State Board of Morticians.
Thank you, Chair Bidle. Charlotte Persephone Hoffman. I am the first Vice President of the State Board of Morticians. And I will not repeat everything that's already been said today in the interest of keeping things relatively brief. I will, however, note one of the reasons why the wrap back portion of this is so important. we sometimes see situations where individuals are arrested for crimes that are relevant to their practice as a mortician, funeral director, licensed transporter, et cetera. But we don't necessarily receive word of that from the police or other authorities. I am the chair of our complaints committee, and we take action largely when we receive a complaint from a member of the public. We can initiate some complaints ourselves when information comes to us, but if we don't have the information about someone doing something, we don't have the ability to do that. This will provide us with further information so that we can do more to protect Marylanders in the provision of funerary services. Thank you, and I urge a favorable report.
Thank you, Charlotte. Do I have any questions for this panel? I don't see any questions. Thank you all very much for your testimony and your support for the bill. And then Sarah Price with the Maryland Retailers, you're favorable with amendment.
Excuse me. Good afternoon, Madam Chair and honorable committee members. Sarah Price here on behalf of the Maryland Association of Chain Drug Stores today. We would respectfully share a few suggestions for the bill based on feedback from our members. It is our understanding that the impetus behind this was to make sure that the various boards were aware of crimes of moral turpitude. So our recommendation would be that if any licensing decisions were to be made based on the results of these background checks, that they focus on crimes of moral turpitude. Additionally, pharmacy technicians already must comply with a background check requirement for their Board of Pharmacy applications, but at this time it does not require fingerprinting, and that type of background check process can take a little bit longer, and pharmacy technicians are already facing a pretty tight window for the training and application process. They have 6 months, and I know that some of the training processes can be up to 400 hours of coursework. So we would suggest that either their current background check requirement be allowed to stand, or consider extending the amount of time that they have to complete the training and application from 6 months to 2 years, as is the standard in our neighboring Virginia. Thank you.
Thank you, Sarah. Do I have any questions for Sarah? No, thank you very much for your testimony and your written testimony. That ends the hearing on Senate Bill 806. I did see Senator Henson come in. So Senator Henson, do you want to present Senate Bill 942, Assisted Outpatient Treatment? Then you have with you Cynthia Lewis, Sean Malone, Ann Hansen, and Paul Nestat.
Thank you.
And I think you have the birthday girl with you, too.
I do, Madam Chair. Thank you very, very much.
Happy birthday.
Thank you very much. And I believe the panel will assemble.
Let me call them again. Maybe they're out in the hall.
Thank you. May I get started?
You can, well, let me call again, and then
Okay.
we'll let you get
Thank you,
started.
Madam Chair.
Cynthia Lewis, Sean Malone, Ann Hansen, and Paul Nestat. And then
Wonderful.
you can begin.
Thank you, Madam Chair. Thank you, colleagues. For the record, Senator Shanika Henson here to present Senate Bill 942, Assisted Outpatient Treatment, Surrender or Seizure of Firearms. This committee is very familiar with the Assisted Outpatient Treatment Program, as it was adopted by this committee in 2024 in the committee's wisdom and great design, and what is really a fantastic program that has been adopted here in the state of Maryland. A person is eligible for assisted outpatient treatment if they have a serious and persistent mental illness. If they have a serious and persistent mental illness that also is not being treated, then they have the opportunity to be a part of a court-ordered outpatient treatment program where they get the benefit of a care coordination team and they get the benefit of a treatment plan. That treatment plan is then monitored by the court. A person who is a good candidate for that is someone who otherwise would not avail themselves of treatment, but it is someone who does have a diagnosis of a mental health condition. A part of the assisted outpatient treatment program, as it was designed and adopted, had a provision in it that left out a key and critical feature. And it requires legislation to correct that key and critical feature that was left out. A part of the existing code states, and what was the original language of what's been adopted into law, is that this subtitle may not be construed to abridge or modify any civil right of the respondent, including any right relating to a license, permit, certification, privilege, or benefit under any law. Now, on its face, that sounds like a really good intention, and it was a good intention at the time, but what we overlooked in that is firearms. If a person has a firearm, wants to purchase a firearm, but they have a severe and persistent mental illness that is not being treated, we overlooked in adopting that provision in the original code that would not be an ideal candidate to have a firearm. So that's what this bill does, is it corrects that small loophole that was left there so that we can intervene and save lives of the people who are the subjects of these orders and those who may encounter them as well. The mechanics of the bill and the way that Senate Bill 942 works is that when a person fills out a petition for assisted outpatient treatment, they would be asked on that petition, does the person own a firearm? And then they would be asked as well, is the person likely to cause a injury to themselves or to others with a firearm? If those two things are responded to in the affirmative, then the court would be required to make a determination, and if the court finds in the evidentiary hearing that the person would be likely to harm someone, then the court shall order the surrender of firearms. And that language there, if it feels familiar because it's similar to what's in our protective order statute, similar to what's in our ERPO statute as well, and the way that the firearm would be surrendered mirrors those statutes as well. It would have the person voluntarily surrender that firearm, and if they don't voluntarily surrender, it does have some enforcement mechanisms in there where the state's attorney or law enforcement office could file for a search warrant or could use the contempt powers of the court to compel the person in to produce the firearms and could do that. I will let you know, in going through your bill folder and the testimony provided by the Department of Health, the Department of Health is not in favor of the option to use the court's contempt powers because the court's contempt powers are intentionally left out of the rest of the statute for assistant outpatient treatment by design. They wanted it to be more collaborative and less compulsory. So it's in the committee's wisdom to decide what to do there. I'll only state that when we're dealing with firearms and we're dealing with a threat to public safety and a person's own safety, that we're in a different area as it relates to someone's harm or potential harm of another. And so perhaps the contempt power of the court is an appropriate tool there. I'll also note that sometimes folks will say, well, we already have ERPO laws. Why do we need this? And several things are true in why we need this. One, for the ERPO laws, there has to be an immediate danger that's happening. The immediacy that's required in ERPO is not the same standard that's here for assisted outpatient treatment. This standard is more prospective in terms of the condition that the person has and the treatment that they're not receiving and what their behavior might be inclined to do since they're not in a state of receiving the care and the treatment that their diagnosis says that they need in order to live well to their fullest potential. Also, we don't want redundancy in the court. If we can avoid the same family, the same petitioner going in to file a AOT petition and an ERPO petition, then we'd rather simply have all of that handled in one petition so that it's streamlined and the person that's the respondent that has their due process to come in isn't the subject of multiple petitions but can have that done all at once. So for that reason, judicial economy and then just the different standards of immediacy, we believe that this is the best vehicle for doing that. You will hear from the testimony that's here for you today. There are mental health professionals who work with folks who are the beneficiaries of the AOT program that you designed. And what they will share with you is that the #1 beneficiary of passing this bill will be the respondents who are the subjects of these petitions, particularly folks who are in a position where they have suicidal ideations. What the practitioners will tell you is that in instances of attempts for suicide, the number one most successful method for completing a suicide is when the method is by firearm. So if we are able to separate folks from firearms while they are receiving treatment for a diagnosed mental health condition, then we know that we'll be able to save lives as well. I am of the perspective as a legislator that there are some bills that we file that have a certain degree of inevitability, where you file a piece of legislation and you know that at some point something is going to happen where people will understand the usefulness for the legislation, whether it's when you file it and you can prevent something from happening, or whether it's in a future year if a bill is unsuccessful. And I believe, colleagues, that this is one of those bills that we will either revisit out of necessity, or we will take on and we will use it as a preventative measure. So with that, Madam Chair, I will turn it over to my panel and I will ask for a favorable report on Senate Bill 942.
Thank you, Senator. Cynthia Lewis.
Good afternoon, Chair and members of the committee. Thank you for the opportunity to testify in support of Senate Bill 942, adding a firearm restriction to Maryland's assisted outpatient treatment program, which becomes active in July 2026. My name is Dr. Cynthia Lewis. I am Director of Adult Psychiatric Emergency Services at the Johns Hopkins Hospital. I am co-chair of the Legislative Committee for the Maryland Psychiatric Society. I testified providing oral and written testimony for the AOT bill that got passed in 2024. The views today are my own and those of the Maryland Psychiatric Society. They are not representative of my employer. This legislation is a focused, safety-driven measure designed to reduce preventable deaths, particularly suicide, among individuals with severe mental illness who are under court-ordered assisted outpatient treatment. Suicide remains one of the leading causes of death in this population, and firearms are by far the most lethal means. When a firearm is used in a suicide attempt, death occurs in the vast majority of cases. Reducing access during periods of heightened clinical risk is one of the most effective, evidence-based strategies that we have to save lives. The purpose of this bill is not to criminalize mental illness. It is to improve safety during a period when a court has already determined that structured treatment is necessary due to significant risk and instability. Assisted outpatient treatment is a civil treatment-focused intervention. Aligning it with a temporary firearm restriction is consistent with its protective intent. Importantly, this legislation includes due process protections. Any restriction occurs within a judicial framework with clear standards and oversight. There is no criminal pathway attached to the surrender of firearms under this bill. The goal is compliance and safety, not punishment. The surrender process is civil and preventative, not prosecutorial. Most states with AOT statutes already include some form of firearm restriction. Maryland's program should reflect the same commitment to public safety and suicide prevention as we prepare for full implementation in 2026. This bill is about protecting vulnerable individuals during periods of acute risk while respecting constitutional rights and due process. It is a measured, responsible step that prioritizes life and safety. For this reason, I respectfully ask for a favorable report.
Madam Chair, members of the committee, my name is Sean Malone on behalf of MPS. Over the summer, and I want to thank the Senator for taking the time this summer to work through what we believe is a common sense approach and addresses many of the concerns with the introduction of this bill last year, where there was a criminal penalty attached. This bill removes this process from the criminal from criminal jurisdiction. It makes it a civil process. It provides due process to an individual, and it is not the permanent removal of a weapon from an individual. It is a temporary removal until they've completed treatment after the courts made a determination that the individual could be of harm to themselves or to others. We believe that this is a safety measure that not only protects the individuals, but it protects others in the community as well as within their family. We want to be clear that this is not taking away an individual's gun right. It is not criminalizing somebody who's in need of mental health treatment or is in crisis, but it is the temporary removal through a contempt proceeding, if needed, to enforce the forfeiture of the weapon for a brief period of time. With that, we would urge your support of this legislation.
Thank you. Now we have two of your panel members virtually, and then we'll ask questions. Is that okay, Senator?
Thank you, Madam Chair.
You're welcome. So if I can hear from Ann Hansen. If you unmute, Ann, and go ahead.
Madam Chair, members of the committee, thank you for allowing me to speak today. My name is Dr. Annette Hansen. I'm speaking on behalf of the Maryland and Washington Psychiatric Societies. You have my written testimony. I'm not going to repeat all of that here. I would like to add some background. However, when we supported the assisted outpatient treatment bill, we didn't realize until the very end of the session that we had neglected to address this very important part, which is the issue of gun ownership. We already have that covered in our civil commitment procedures. Our intent was to make the AOT process as parallel and analogous as we could to the inpatient civil procedure. So an inpatient civil commitment hearing requires a judge to determine first that there's clear and convincing evidence of dangerousness due to mental illness. Then and only then would the judge consider the evidence on the record and make a decision about gun ownership. That's exactly what this bill would do. There's still a requirement for the individual to have a clear and convincing evidence of risk of dangerousness due to mental illness. The difference is that this bill would give more due process protections to someone under an AOT order than a civil commitment person. There would be no requirement for a relief of disability process. The restriction would end automatically when the AOT order expires. The advantage is that instead of doing an IRPA with an AOT order, you would then have two orders running in parallel but potentially out of sync with one another. So you could have someone whose AOT order expires, they'd be under the mistaken impression that they could buy a gun or own a gun when the IRPA order was still in effect. That would not be a good way to handle this. So having this into a single procedure is less burdensome for all parties concerned.
Thank you, Doctor. And I think we have one more doctor, Paul Nestat.
Yes, thank you, Madam Chairman and members of the committee. My name is Paul Nestat. I'm a psychiatrist. I work inpatient with a severely ill population. I'm also a suicidologist, an epidemiologist, and medical director of the Center for Suicide Prevention at Johns Hopkins, and I'm the chair of the Maryland State Suicide Fatality Review Committee. But I'm here speaking on behalf of the Maryland Psychiatric Society as well, not on behalf of my employer. It's important to recognize that suicide rates in the U.S. have really been climbing dramatically, and the data from Maryland that just came from the CDC last week showed in the latest year of data, we've had a 10% increase in suicide in Maryland specifically. And most suicide deaths, the most common method of suicide death, are by firearms. It turns out that we're not very good at figuring out who's going to attempt suicide, to pick out which among the high-risk population will attempt suicide, but we know who of those attempters will die will be those that have access to a firearm. Most attempts are survived, 92% of suicide attempts are survived, but if you use a firearm in your suicide attempt, you will die 90% of the time. And that's why it's so important to address lethal means access as a suicide prevention strategy. We have to think about who we're talking about when we talk about the people adjudicated to AOT that would be sort of relevant to this bill. These are the highest risk patients among the highest risk patients. These people being adjudicated to an involuntary outpatient treatment because of a history of multiple hospitalizations, history of dangerousness. These are folks that are probably the highest risk for suicide, and in some rare cases, gun homicide, but the majority of what I worry about is suicide. This bill would allow this population to continue living if they do become suicidal and make a suicide attempt. If there's not a gun around, they're very likely to survive that attempt, come into treatment, come into care, we get them better. We know the vast majority, 94% of people who survive a serious suicide attempt keep on surviving. They don't just try some other method. They get treatment, they get better. The tragedy is when they have a gun, and so they are not able to survive to get that treatment. So I want to emphasize this restriction is a temporary one. It's a very narrow scope, very high-risk patient population. It's not about punishment. It's about preventing a permanent outcome during a temporary crisis. So I encourage a favorable report.
Thank you, Doctor. I see Senator Lamb has a question.
Thank you, Madam Chair. Thank you, the bill sponsor. Just a follow-up question. Some of this you touched on already, but just trying to clarify here. So obviously sympathetic to the concern of firearm access and suicide risks. Obviously that's correlated. The department, as you referenced, I think is opposing this, tying this directly to AOT, to assisted outpatient therapy, because of the potential, I think, stigma that it seems to imply. And in your testimony, you had referenced that, some openness to working on kind of wording on that. Is there, we can explore language. I wanted to see if we could try to find some way that would make it easier to apply IRPOs, the extreme risk protection orders, instead of just tying it explicitly to AOT itself.
Thank you for the question, Senator. The department's testimony I appreciate the department's testimony. I think they do acknowledge the need for handling the issue of access to a firearm while a person is under treatment, but the solution that they offer there is the criminal code. In the department's testimony, it mentions that a person could be subject to criminal penalties if they attempt to possess or purchase a firearm while they have a mental illness. And we don't think that it's appropriate to use the criminal code. So while the department was not in alignment with simply the contempt mechanism that's provided for in the bill, what they offered as an alternative was something that was in a previous version of the bill, and we did look at it, and it was not something that the community, medical community, the treatment community wanted, or the public defender's office or other players that would be involved in a criminal proceeding that dealt with that. So that was something that we explored and decided wasn't an appropriate route to go. If we did strip the contempt portion out of the bill, as the department has suggested there, what's left there is the opportunity for a search warrant that could be applied for by the state's attorney's office or law enforcement. So there is still an enforcement mechanism if the contempt is taken out, but I would put it into the wisdom of the committee, but I do think the contempt has some value, and it wouldn't, again, be broadly used to enforce compliance with AOT, because I do believe, as the department highlights, that is counter to the spirit of AOT. It's supposed to be engagement and to get a person onto the path of voluntarily getting treatment. So we certainly didn't take it that far. But, Senator, in your wisdom, certainly I'm not a physician, and if the committee thinks that it should be different, then I certainly would defer to that.
So you're open to other ways to make it easier to apply ERPOs instead of trying to explicitly tie it to AOT, I guess, per se?
I think some of the challenges, we explored that. As the testimony bore out, we've been working on it in the interim. I introduced the bill last year, and we did spend the interim working on it. The ERPO process could be misaligned with AOT. If the ERPO is granted for 6 months or for a year, and let's say the person has treatment that lasts longer or treatment that's shorter in duration, and then you could still be subject to an ERPO, whereas under the bill, the person could regain access to their firearms as soon as the AOT order is terminated. So it would take some work to try to align the orders with the exact same duration. And then the ERPO requires an immediacy in terms of the danger that's not required here in the AOT order. So when we were looking at them and trying to say, could we just kind of piggyback the processes, they had some differences that made that not completely lockstep.
Yeah, and I guess that was the last point that I was going to touch on there, is that the way AOT is currently set up, it will probably take a lot longer to go through a process to remove that firearm than an ERPO kind of process to get a hearing and have that removed, right? So there's a time discrepancy here that, like, you know, if there's some way to kind of speed up that process for these folks, we'll try to see what we can do.
Yes, and what you're describing is immediacy. So if there is an immediacy that's there with the danger, then maybe an ERPO would be appropriate. So certainly it wouldn't be exclusive if a person if they fit all the criteria for that, this wouldn't take away the ability to pursue that in addition to.
Right, just going down the AOT route, it just may not be the fastest route to go through, but, you know, happy to think through that, so.
I appreciate it, thank you.
Okay, thank you.
Thank you, Senator. Senator Reedy?
Madam Chair, and I had some meetings in my office about this before. I think Dr. Nesbitt was there with me, and we talked about this issue a little bit. I wondered if I could, just going back to the department's letter, and you've been discussing it some, their contention on their opposition letter is that, it's on the second page, under current Maryland law, individuals who are prohibited from possessing regulated firearms include individuals who suffer from a mental disorder as defined in 10-101 of the health article and have a history of violent behavior against the person or another, or if they've been voluntarily admitted for more than 30 consecutive days, and obviously if they've been involuntarily committed. I understand why we were trying to get at this issue, and I don't believe somebody who's mentally ill should have a firearm, at least, you know, certainly while they're experiencing that kind of mental illness. But I also struggle with this question of, we already covered a good part of the law, So I don't know if you could comment on their department's opposition. It seems like a lot of their opposition seems to be focused on the compulsion, but if you could comment on their opposition there, that it's already kind of covered under Maryland law.
So what the department references is the criminal code, and we did have the criminal code in the prior year's version of the bill. And the wisdom of the group is that we wanted an option that didn't require a crime to be charged, because we want treatment to be the focus of AOT. So we took the criminal code out of the bill and we allowed for enforcement that was non-criminal. But you're right, Senator, in that the department's alternative is to rely on the criminal code, and we thought that that was not the best option.
And I don't want to retrod the ground from Senator Lane. I appreciate that answer about the contempt powers issue. But if we start to get outside of the AOT process itself to introduce something new, maybe explain to me this. How does the process work right now where someone comes into an AOT proceeding? How do we discover they have a firearm or not? Like yeah.
Hi, well, one, AOT has not been, it doesn't come active until July 2026.
Right.
So we're not operating under AOT right now. Right. I will say, when we mentioned some of like the voluntary admission for 30 days and the involuntary commitment, a lot of the patients that I see do not meet that criteria. There are a lot of patients who will meet criteria for AOT who do not get involuntarily certified. They often come in voluntarily. They often get discharged after 5 to 6 days because they're ill, but they're no longer dangerous, but they're not taking care of themselves. And then when they get discharged, they fall into the same, not taking their medicines, becoming acutely ill. So we realized that if we followed the rules now with where firearms can be taken away, a lot of the patients under AOT will not meet that criteria, which is why we didn't want to rely on that.
But so it's interesting because we set up the whole AOT, and I've been a big supporter of AOT, so I'm glad we've set it up. We've set that up because the challenge is figuring out how to deal with people who have not been an imminent threat to other people or themselves that we can show, but have shown that they're having problems, a lot of problems, just trying to get ahead of it, right? But now we're trying to take some things that were constitutional restrictions, constitutional rights. We're trying to take things that they haven't lost yet and say, well, now we're going to start taking those things away in the AOT process. I think that's my concern. Putting aside how you feel about firearms in general, and I had a great discussion, like I said, with Dr. Nesbitt about, culturally, like in my county, almost everybody might own a firearm just because they've had them. It's not the same as people who are, I think sometimes down here when we talk about guns, there's some folks that are not really as big into firearms kind of see it as a bunch of gun enthusiasts running around. I said, well, no, a lot of people in Western Maryland, Eastern Shore, they have a firearm in their household that they've had, they have a shotgun or whatever. So when we start talking about taking away a particular right, the whole point of AOT was we're trying to be real careful in balancing that. So I don't know Sean, I don't know if you have any comment on that, but.
Yeah, I think we're very sensitive to the idea of the removal of a weapon. So it's restricted to the time that the individual's in crisis. And there's due process. If you notice that what was discussed was, we're talking about the clear and convincing standard. We're not using the normal standard, which would be a preponderance of the evidence.
So this has to be clear and convincing in this AOT proceeding?
Yeah, that's my understanding, yes. So that the individuals have harm to themselves or others, and that there's a crisis going on. So it's a temporary removal. It's not taking away the right to bear arms. It's just a temporary removal so that they can get the treatment they need, right, and then come back. So and we're sensitive in drafting that, and this bill, and I really do mean it. The senator and Delegate Phillips spent a lot of time this summer trying to take the feedback that we received from the committees to craft this bill to address those issues, to solve a real problem, which is, as any of us who have had a person in mental crisis in our family knows, that we don't want harm to come to them. We don't want them subjected to a criminal proceeding, but we certainly should take the steps to protect them from much like, not letting them drive a vehicle, not letting them utilize alcohol during that time. The same types of things that they're entitled to do, but for that period while they get treatment, that's what we're really trying to address. And I think we've narrowly tailored this bill and done it in a fashion that's sensitive to the individuals.
I do like that the bill lays out very clearly how the process works and how you would regain that right once, because we do want people to get into treatment, and we don't want it to be an obstacle to treatment.
Right.
It's a very tough issue because it's a right, and so I appreciate. I'll keep looking at the testimony. Maybe we look at the contempt issues one way or the other, as the sponsor mentioned. But thank you very much.
And I also wanted to add that these patients, this is a very small population of patients. These are patients who are chronically ill, patients who really, because of their lack of insight and what we term anosognosia, that they don't even recognize they're ill. These are the patients that I see regularly in my emergency department who aren't caring for themselves, who are not realizing that they are probably going to die an early death if they don't care for themselves. So they're not even really in crisis, they're just in chronic crisis. So again, these are patients that when I see them, if they had access to a firearm, that would be very unsafe.
I think with the concern on the contempt, if I may, Senator, the concern on the contempt issue, the courts possess the authority in any case to hold somebody in contempt for not following an order. So it's the minimal that they have. It's already something. So in fact, to say you couldn't hold somebody in contempt or use your contempt power to help enforce the order would be hamstringing them in trying to effectuate the decision that's been made with regard. So I think it's a pretty low level that we've gone to. We're not talking about, the criminal penalty that would scar somebody. It's just enforcing their own order if there's not compliance.
One more question. I'm so sorry.
That's all right, we only have, 10 minutes.
I know, no. Well, where does AOT go on people's records? Does it ever show up in case search? Does it come up on background checks?
No, it should not.
It's a confidential health record.
That's what I thought.
Yes.
I'm just checking. Okay, I'm sorry. Thank you, Madam Chair.
It's okay. Senator Kyle.
Yeah, thank you, Madam Chair. I just have, I think, one quick question, and I don't know if maybe the bill sponsor or perhaps, and thank you very much for this bill, or maybe Sean, if you could answer it. I was just looking at the testimony that was submitted, and I don't see anything from what we see as our usual, patient advocates like NAMI and others, and I'm curious what the conversations may have been with them, if anything, about this bill, and if you are aware if they've taken any position related to it? I'm not. You're not?
I have spoken, I worked very closely with the advocates. I don't want to speak for them.
Mm-hmm.
I have been in discussion, and I would rather I think we're planning to be here today, but the goal is to get to yes.
Okay. Yeah, I'm just curious why I don't see anything submitted, but thank you. Thank you, Madam Chair.
I'm happy to follow up offline, Senator, because I don't have the answer to that question, but I'm happy to inquire and get back to you. Yeah.
Senator Lamb.
Yeah, thank you, Madam Chair. Just a follow-up question to my colleague from Frederick and Carroll County. Just to clarify, because I think, Mr. Malone, you had mentioned that this is a clear and convincing kind of evidentiary standard that's here. When I look at this bill on page 3, it says if the court determines that the respondent is likely to endanger or cause physical injury, that is not the clear and convincing standard. To Senator Reedy's point, the clear and convincing standard is to AOT itself. Correct. As to whether someone's eligible for AOT. This standard is a standard that's lower than that. It's likely a danger to cause physical injury to the respondent. So I just want to be clear about that.
Absolutely, and that's what I was referring to with regard to, but to get to that finding, you have to make a clear and convincing finding. And then there's an issue of are they likely to do harm? That's fair, and if I misspoke, I apologize. But you don't get there without the prerequisite first finding.
If I could just add, that actually brings up a really important point, which is that unlike the version of this bill last year, in this case, first, the person needs to be adjudicated to AOT, which has the clear and convincing standard. But that's not automatically then addressing the firearm issue. Once that person is adjudicated in that way, the judge has a further decision to make, where among this very high-risk group of AOT people, there are some that are actually likely to harm themselves immediately when they have a firearm, and then they're put into that group. The previous version of this bill, it was tied more intimately to AOT. This allows it to be a very specific case. And it's also relevant to what Senator Reedy brought up before regarding the existing firearm restrictions in Maryland law, which include involuntary hospitalization, it's actually the case that when someone's involuntarily hospitalized, they're not automatically then not able to get a firearm. In fact, there's a further judge's decision that's actually only limited to if they're a danger to others. It doesn't even address suicide risk. The majority of gun deaths are suicides. So this is something that is really a select few of a high-risk group having their firearms temporarily removed during a period of crisis. I just want to make that very clear.
Real quick.
It's okay, when we're here.
We could have a lot of questions on the floor on this, so I just,
Senator Reedy, thank you.
So let me pick at that, say goodbye to the apple and I'll be done. So the clear and convincing standard is AOT is clear and convincing. Correct. And then once you are adjudicated that you need some sort of treatment under AOT, then the judge has a further decision to make. But the decision about firearms is not clear and convincing, but it is still a court proceeding. I mean, is that?
The judge makes a determination, and the Senator read it correctly.
Is that determination something that's debated in front of the judge?
Yeah, the judge has to make that determination, right? So that would be the argument. So listen, and I apologize.
I'm not an attorney.
It's important to have candor with the committee. That was not my intent.
I understand. Okay. It's okay. And I understand it. It's the text.
Because actually applying any standard, applying preponderance of the evidence or clear and convincing to that is a tricky thing, as you're telling the future, you're predicting the future.
Right, which our red flag law actually does, which is why it's sort of it's that Fourth Amendment conundrum of trying to, and AOT dances on that line too, obviously. So I mean, so it's an interesting challenge there. But then, okay, so all right, I'll have to ask some additional questions offline. Thank you, Madam Chair.
Thank you, Senator. And I don't see any other questions. Thank you. I'm happy that 4 more committee members weren't here.
Yes. Thank you, Madam Chair.
Senator Henson, thank you for this bill.
Thank you.
All right, that ends the hearing on this bill, and now we're going to do Senate Bill 721. Senator Wallstreicher's here. Developmental Disabilities Administration Services. You're bringing Scott Evans, Gregory Snyder, Andy Culp, and Stephanie Henes. Thank you.
Well, good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. So this week is my mother's birthday. Happy birthday, Mom. She turned 74 years old. My father has already turned 74. Why is this relevant to this committee? My sister, who has been very kind to allow me to talk about her experience, has an intellectual disability. And she lives with my parents, and she's lived with my parents for most of her life. She doesn't work right now, but my parents take good care of her. That won't always be possible for my parents. 74 is not young. They're in good shape, but eventually my sister will be my responsibility. And that'll be challenging. It'll be challenging for me. It'll be challenging for my wife. It'll be challenging for my children. And most of all, it'll be challenging for my sister Marcy. But it'll be made less challenging because Marcy is a constituent of Senator Kramer. She lives in Maryland with my parents, and I live in Maryland. So the transition between one home in Maryland and another home in Maryland is a little bit easier for her. That's not always true for all of our constituents. I want to introduce you to my constituent, Stephanie Henes, who is to my right. Her brother, Ralph, lived with her parents in Connecticut. Stephanie is a constituent of mine here in the state of Maryland. Ralph has an intellectual disability. You're going to hear about him today. This bill is named on his behalf. Stephanie,'s mother passed away after caring for Ralph for his entire life. And Stephanie's father, as often happened, his health started to decline precipitously after Stephanie's mom passed away. And so Stephanie's dad became unable to care for Ralph, and a plan was hatched for Stephanie to take care of Ralph down here in Maryland. But the transition between services in Connecticut and services in Maryland was near impossible. The District 18 team, my delegates and I worked for a year to help Stephanie establish services for Ralph. And it was just extremely challenging. This happens every day. Across our state. People are mobile, people move all the time. So we need to create a structure by which people receiving services in other states whose caretakers pass away have the ability to move to Maryland and have a continuity of those services. That's what Ralph's Law in front of you does. And while it doesn't prescribe that those services must take place, we want to create deference to our incredible Maryland Department of Health. It does expedite the process by which those services can be decided upon. How do we know that the bill will work? How do we know that this is possible? Well, the answer is because we already do this in another context. Maryland is part of an interstate compact. Who moves around a lot, oftentimes with children with disabilities, are service members. And so we provide an expedited process, Senator Guile is an incredible leader on this, by which service members who have children with disabilities can receive continuity of services as they move from Germany to Maryland, from Montana to Maryland, from San Diego to Maryland. And so we already do this in one context, and the bill in front of you, Ralph's Law, will expand that to everyone who has a caretaker who passes away in another state and is required to move to Maryland for the continuity of care. Last thing, just to touch on one thing very quickly. In another state, there's been allegations of widespread fraud when it comes to social services. And we wanted to provide protections in this legislation so that we don't somehow open the door for Maryland to become like a hub of social services for people who need it. So what it requires is that the person who's receiving services be receiving those services in another state for at least a decade, to make clear that they've established residency somewhere else. And when the caretaker passes away and that person receiving services moves to Maryland, the new caretaker, Stephanie in our case, must have been a Maryland resident for at least 2 years to make sure we don't open the door to any kind of forum shopping or fraud. With that, Madam Chair, thank you so much for the opportunity. I hope we can have a favorable report on Ralph's Laws, Senate Bill 721.
Thank you, Senator. So let's have Stephanie go next.
Thank you very much. My name is Stephanie Hennis, and I'm here to support Ralph's Act. My brother Ralph is 41 years old. He has autism and an intellectual disability, which cause him to be self-abusive, verbally aggressive, and to engage in property destruction. Some of that actually happened this morning when I attempted to bring him to the doctor. For 20 years, Ralph attended a day program in Connecticut. This was a critical aspect of his care, improved his quality of life, and helped to limit his dangerous behaviors. In November 2023, our mother died unexpectedly, and my father began experiencing cardiac and neurological problems that caused a car accident he didn't remember. Ralph couldn't be cared for in Connecticut, so I submitted a DDA application with my father's medical records and proof of Ralph's residency because I'm his guardian and a Maryland resident. After months of silence, DDA agreed to an eligibility interview, but then placed Ralph in the current request category, which would never result in services. Over the next year, I provided DDA with more documentation, but it was never enough. We were left with a choice to leave Ralph in Connecticut in my father's care or move him here without services. At one point, DDA asked whether Ralph had already been harmed in a car accident with my father, as though imminent risk was insufficient. It felt like DDA wanted to make the process so difficult that we would drop our pursuit of benefits, but that wasn't an option. After my father's hospitalizations, an appeal, delegate intervention, senator's intervention, retaining counsel, and moving Ralph to Maryland without services, he was put in the crisis resolution category, but he still has no day program. Ralph says this makes him sad, and he keeps asking when he'll have a new program. The months of instability have taken a toll on him and my family. He's agitated at night and wakes up my children. No one should have to go through this. Ralph's Act ensures that caregivers who are long-term Maryland residents, like myself, can actually obtain DDA services for their disabled loved ones. Thank you very much. That was perfect timing.
It was perfect. Stephanie, I'm so sorry that you're going through this. It just, I have family members on each side that, you know, there's adult children with disabilities, and I worry about them doing exactly what you're doing. It's very difficult, but thank you for sharing your story.
Thank you so much.
Andy Culp?
Yes. Hi. Thank you, Madam Chair and members of the committee. For the record, my name is Andy Culp, and I'm here this time on behalf of the Maryland Developmental Disabilities Coalition, 5 statewide organizations that are committed to improving the opportunities and outcomes for Marylanders with intellectual and developmental disabilities. And we support Senate Bill 721 to ensure continuity of services for people with IDD who must relocate to Maryland following the death or incapacitation of a primary caregiver in another state. And the death or loss of a primary caregiver is one of the most disruptive events in a person's life. And for people with intellectual and developmental disabilities, it's not just losing a parent, it's losing stability, housing, and consistent care. And usually the next person in line to provide housing and care is a sibling, and sometimes that sibling resides in another state, making it necessary for the person with intellectual and developmental disabilities to move. And as previously stated, this legislation appropriately narrows the circumstances under which a person may receive an expedited evaluation for IDD services in Maryland. They need to have received home and community-based services for 10 years in another state. They're moving to Maryland to live with a family member who has resided in the state for a minimum of 2 years. And if found eligible for services from DDA, the person's placed in the crisis resolution category of priority on the DDA waiting list. So there's 3 categories on the DDA waiting list: crisis resolution, crisis prevention, and current request. Crisis resolution, usually a person is homeless, they've lost their primary caregiver, they're in imminent risk of harm, so that's why this category is most appropriate. Crisis prevention just means the person may be in crisis in the coming year, maybe not. Current request is where most of the people exist on the DDA waiting list, and people can be in that current request category for 15 years. So it's not an option for people like Ralph. So for all these reasons, we hope that you will see how we see it, and we support Senate Bill 721.
Thank you, Andy. Gregory, you want to go next?
Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the Senate Finance Committee. My name is Greg Snyder, and I'm here on behalf of the Maryland Association of Community Services in strong support of Senate Bill 721, or Ralph's Act. Senate Bill 721 establishes a clear and timely eligibility process for people with developmental disabilities who must relocate to Maryland after the death or loss of a parent or primary caregiver. It creates a narrow and compassionate pathway for people who have received home and community-based developmental disability services in another state for at least 10 years and are moving to Maryland to live with family. Under this bill, the DDA must issue an eligibility decision within 30 days in this circumstance. If determined eligible, the person is placed in the crisis resolution category of the DDA waiting list, recognizing the urgency of the situation while also maintaining the structure of Maryland's existing system. The death of a primary caregiver is one of the most destabilizing events a person can experience. For someone with significant support needs, it can mean the immediate loss of housing, daily supports, and their stability. A 30-day eligibility determination provides clarity and predictability during an already traumatic transition. In many cases, a sibling or other family member in Maryland is the only available caregiver. When families step forward in moments of crisis, they should not have to face prolonged uncertainty or administrative burdens while they try to stabilize their loved one's supports. Placement in this crisis resolution category appropriately acknowledges the urgency of these situations while preserving fairness within Maryland's existing waiting list framework. The bill also ensures alignment with the current system while responding to rare but urgent circumstances. People who have relied on long-term home and community-based services should not lose continuity of support solely because they must relocate to Maryland after losing a caregiver. For all these reasons, Max and our members are asking for a favorable committee report in Senate Bill 721. Thank you.
Thank you, Greg. And then you must be Scott Evans.
Yes.
Thank you.
Good afternoon, Madam Chair. My name is Scott Evans. I am the CEO of the Benedictine School located in Ridgely in Caroline County. Benedictine is a non-public special education school, an adult community service provider for children and adults with developmental disabilities. I am here today in support of Senate Bill 721, both as a professional in the field and as a friend of a family that is currently going through a situation similar to the one described by Ralph's sister. Last fall, I was approached by a family I've known for the past 10 years to discuss a unique situation they are facing. Joe and Julie live and work in Queen Anne's County, and we met through our sons being on the same swim team 10 years ago. Joe's parents live in upstate New York, where his brother receives services through a local community provider and is funded through a Medicaid waiver program in New York. Joe's father has been recently diagnosed with dementia and has been in and out of the hospital and rehabilitation facilities. His mother has been supporting her husband's care while juggling care for her son. This has also taken a toll on the mental and physical health of Joe's aging mom. Joe asked me about support options in Maryland when it becomes apparent that his parents can no longer support his brother in New York. Joe would like to have his brother move to Maryland at that point, where Joe can take over as the role of primary advocate and supporter for his brother. Joe and his family are doing the right thing by planning now for what will be an emotional and difficult situation for their family sometime in the near future. Senate Bill 721 would ease the anxiety of this transition on Joe and his brother. Senate Bill 721 would give a pathway for a family like Joe's to ensure their loved one is properly supported through a difficult family transition. As a professional in the field, I see the shift of primary advocate and caregiver from parents to siblings often, and each year it is increasing. While each family dynamic is different, Senate Bill 721 would offer family options on how best to support their loved one. I respectfully ask for your support. Thank you.
Thank you. I don't see any questions. It was almost all favorable. We're going to work with MDH. Thank you all very much for your testimony. Thank you. That ends the hearing on Senate Bill 721. I think now we're going to go to Senator Augustine here. Okay, Senator Augustine. Senate Bill 773, Health Occupations, Pharmacist Vaccination Orders. And you have Alan Vandell from AstraZeneca and Dolores Sanchez from Cornerstone. Dolores, someday I'll be able to pronounce your last name.
That's all right. I think you're doing good.
All right, thank you. Chair Bidel, members of the committee, Senator Malcolm Augustine here on behalf of Senate Bill 773, Health Occupation Pharmacist Vaccination Orders. Madam Chair, when I walked in, I saw our former colleague, Senator Kelly, in the back, who, when she was vice chair of HGO, she and I worked on moving the policy to help have to create access for young people to receive vaccines in our pharmacies. And we worked really closely on that, and we created guardrails in that process. And this committee and our legislature has done that. We created that with those guardrails to make sure that youngsters would be able to get appropriate vaccines. And what this piece of legislation is really, it's really a technical piece of legislation, because there are these self-administered vaccines that have gone through all approvals. They are appropriate, but just because of the way that we did craft the legislation, there really is a need for what I would call, again, like a technical change that would allow for these self-administered vaccines to be given to an authorized adult caregiver, which would be an appropriate guardrail for at the pharmacy location. Again, so it's just like, really, we're not adding anything new, anything else like that, because right now, the way it's written in the existing statute, the pharmacies are not allowed to basically have it out of the pharmacy. They are available. Again, we're just talking about those that are already approved, got all the approvals, and are in the right place, but we just want to continue with using our pharmacies as places of access for things that are very important pieces of care for Marylanders. So that this legislation really is, like I said, it's technical. It's not a policy expansion. It really clarifies pharmacists' authority where there is actual ambiguity in our current statute. It reflects existing FDA approvals and modern clinical practice and preserves patient safety and professional oversight and supports Maryland public health efforts without promoting or favoring any kind of specific product. For these reasons, I'm going to respectfully urge a favorable report on Senate Bill 773. Thank you.
Thank you, Senator. Who would like to go next?
I would. Chair Vital and members of the committee, my name is Alan Bandel, and I'm the U.S. Medical Lead for Influenza at AstraZeneca. AstraZeneca is a global science-led biopharmaceutical company here in Maryland, and it's the home to our largest U.S. footprint, including advanced manufacturing and research and development operations. We employ over 5,500 folks from Maryland at sites in Gaithersburg, Frederick, and Rockville. AstraZeneca appreciates the opportunity to share its support of Senate Bill 773. Vaccination is great. Processes are greatest and strongest when patients are offered multiple complementary pathways to care that may reduce barriers to access. This bill updates Maryland's laws so residents can access vaccination through modern FDA-approved delivery approaches. As new forms of vaccines become available, it's important that state law clearly enables pharmacists to participate in these models in a way that's consistent with their training. Pharmacists are well-known, trusted community-based access points, and pharmacists play an important role in helping patients navigate vaccine options. This does not disrupt the current existing processes or existing care. Patients can still be vaccinated in the provider offices, clinics, and in pharmacies. It does provide an opportunity that adds flexibility for patients, busy parents, and caregivers who need it. Importantly, safety and oversight are built in. Self-administered vaccines follow FDA-authorized prescribing information, defined eligibility screening, counseling, follow-up, and importantly, reporting through Immunet where you document vaccination. Senate Bill 773 is a pragmatic step that strengthens our public health, expands access, reduces barriers, yet preserves patient choice and reinforces pharmacists as an accessible healthcare provider. On behalf of AstraZeneca, we specifically urge a favorable report on Senate Bill 773. Thank you for your time and consideration, and I'm available to answer any questions.
Thank you. Let's hear from Delora, and then we'll see if we have questions.
Thank you. Good afternoon, Madam Chair, members of the committee. Delora Sanchez-Ficalche with Cornerstone Government Affairs. I want to first thank the sponsor of this legislation for his leadership in this space and continuing to work with us here so that we can also allow a different modality for vaccines. This bill is best understood as a narrow technical clarification that clarifies statutory ambiguity because we have a new modality of providing vaccines, and we want to be able to allow folks to have access to that as well. So Maryland's vaccination statutes were written at a time when the delivery model was straightforward. A licensed professional physically administers a vaccine to the patient, and the statute works well for that model, but it does not clearly address vaccines that are designed to be prescribed and dispensed by a pharmacist and administered by the patient or caregiver. This gap is not about safety, eligibility, or scope of practice. It is about how the statute treats the method of administration. Senate Bill 773 resolves that ambiguity. It clarifies when a vaccine is designed for self-administration. Pharmacists may prescribe and dispense it consistent with their existing professional standards and regulatory oversight. Nothing in the bill creates a new vaccine, expands who may be vaccinated, mandates use, or alters existing vaccination programs. Importantly, all safeguards remain intact. Pharmacists continue to operate under licensure requirements, written protocols, patient screening, and counseling standards and reporting obligations. This bill preserves it while allowing the system to function as intended. In short, Senate Bill 773 is a modest but necessary update to ensure Maryland law accommodates modern vaccine delivery without compromising safety or standards of care. For those reasons, I respectfully urge a favorable report on Senate Bill 773.
Thank you for your testimony. I don't see any questions. We do have Ms. Horton from the Maryland Pharmacists Association favorable here, so would you like to come up?
Do we stay? or do we go?
You guys are done.
Okay. Thank you.
Aaliyah Horton, Executive Director of the Maryland Pharmacists Association. We are here in support of Senate Bill 773. As was mentioned, it is a clarifying bill. We've had a number of conversations about this gray area, so I'm really happy to see this legislation. My understanding is that it is based on feedback from the Attorney General's office as well as feedback from the Board of Pharmacy. So with that, we are in support, and I will leave it there. Thank you very much.
Now, we do have two unfavorables virtually, I think, Sarah Cusack and Catherine Garrett. So Catherine's on. Catherine, can you unmute and give us your testimony, please?
Good afternoon, Madam Chair, Mr. Vice Chair, and members of the committee. Thank you for your time today. My name is Catherine Garrett, and I am the chair of the Love Maryland PAC. We have over 3,600 members statewide and focus on consumer protection in the healthcare sector. I'm here to urge an unfavorable vote on Senate Bill 773, which would allow pharmacists to order vaccinations for children as young as 3 without administering them themselves. While well-intentioned, this bill dangerously expands the scope of pharmacy practice at the expense of patient safety and comprehensive care. This is a special interest bill. This is a bill for padding corporate bottom lines of companies like CVS. It's not a bill about the health or safety of minor children. If a pharmacist orders a vaccine, but someone else, perhaps an untrained caregiver, administers it incorrectly, who bears the liability? The bill's safeguards, like reporting to Immunet, are insufficient without direct oversight. This isn't about convenience, it's about accountability. To my understanding, after speaking to several elected officials in both chambers, caregiver is not clearly defined in this part of the code. A judge could likely assume the definition to be anyone with the care and custody of the child to be considered a caregiver who can lawfully consent to and administer the vaccination. Should this bill move, the Love Maryland PAC would strongly encourage the language be amended to remove caregiver and replace that with parent or legal guardian, as that is the only person or persons who should be able to consent to the vaccination of a child. Finally, this bill, like so many others we have seen since COVID, erodes the role of primary care providers, which leads to fragmented medical care. The best location for vaccinations and discussions about vaccinations is with your primary medical professional. The Love Maryland PAC strongly encourages an unfavorable vote on SB 773. Thank you.
Thank you. And Sarah? Unmute. There we go. Thank you.
Good afternoon, Chair Beidel and committee members. My name is Sarah Cusack with the Alliance for Science-Based Policy. I submitted an article from the Children's Hospital of Philadelphia that lays out some of the many concerns that we have with this bill. One issue is that children who get their vaccinations through the VFC, the Vaccines for Children program, are ineligible. As that program rightly requires the child to see an in-person healthcare provider, because that is obviously in the best interests of the child. We are extremely concerned about the term caregiver in the bill. That would have to be defined and corrected for us to approve of the bill. The bill is being proposed as a time saver for busy parents, but that's not true. The caregiver would have to interact with online ordering. Once they get the kit, they have to either watch a video or read administration instructions, which currently are only available in English. And then after they've administered the product, they have to pack everything up and ship it out because it is medical waste. The nasal flu mist is a live virus product. That is serious medical waste. And part of this procedure is that the caregiver has to pack it up and make sure that they get it out of the house. The CHOP article says that pharmacists will report to Immunet based on the address where the flu mist is shipped. So there's no real way to document who actually received the vaccine. And if you're talking about a busy household, it is possible that the package could get left in a back room somewhere, no longer be at the right temperature, and never even be used. So there's no way to document who received it. Finally, we always advocate for people, especially children, to get their vaccinations with a healthcare provider. And that's just a few of the reasons that we oppose the bill. Thank you.
Thank you for your testimony. I don't see any questions for this panel. That ends the hearing on this bill. Thank you very much. We are now going to go to Senate Bill 874. We have Michael Godfrey is going to do the presentation. Michael, I don't see, you don't have a panel, it's just you. Just me. Thank you.
Good afternoon, Chair Beidel, Vice Chair Hayes, and members of this committee. For the record, I am Michael Godfrey, Master's Social Work student and Legislative Fellow with Senator Mary Washington, and I'm here to present Senate Bill 874 on her behalf. Maryland social workers show up every day in schools, hospitals, community health centers, state agencies, and neighborhoods across this state. They do case management, crisis intervention, policy work, program administration, and community organizing. But the way Maryland law currently defines and describes the social work profession has not kept pace with that reality. The statutory language is narrow in ways that can render large parts of the profession invisible, particularly the macro level work that social workers do. Senate Bill 874 is rooted in the idea that the law should reflect the full breadth of what social workers are actually trained and licensed to do. That means modernizing outdated language and building in explicit recognition of community practice, advocacy, policy, and organizational work alongside the clinical functions that are already well established in the article. Since the bill was introduced, Senator Washington has heard from the Board of Social Work Examiners, NASWMD, and other stakeholders who have raised important concerns about the scope of these changes and the need for broader input before moving forward. The senator takes these concerns seriously. To that end, she would welcome an amendment to convert this bill into a formal study, bringing together practitioners, advocates, and the board to develop recommendations for the General Assembly to act on with confidence. We appreciate the committee's time and consideration and respectfully urge a favorable report. Thank you.
Thank you for your testimony. I don't see any questions. You got off easy. We have Ann Seacott, favorable with amendment, and Christine Crone, favorable with amendment.
Good afternoon, Madam Chair, members of the committee. I'm Ann Seacott, testifying today on behalf of the National Association of Social Workers, the Maryland chapter. We are very appreciative and in agreement that it is a worthy effort to try to update the scope of practice, the title for social workers, and at all levels. It is an important task. We are especially supportive of making sure that the macro level social worker profession is raised in an appropriate way in the code. We do just think that this needs time. Any health occupation code, the language is really important to make sure we're not inadvertently leaving something out, that we're not conflicting with something else elsewhere in the code. So we are very happy to participate in an effort during the interim to try to bring a complete and wonderful product to you next year. So with that, thank you.
Thank you, Ann. And I misspoke. Christine is unfavorable.
Thank you. Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the Finance Committee. I'm Christine Crone on behalf of the Maryland Legislation and Advocacy Committee of the Greater Washington Society of Clinical Social Work. I was not aware that the sponsor was going to propose that type of amendment, and with that noted, I will say me too to what Ann said. Thank you.
Thank you, Christine. I don't see any questions. That ends the hearing on 874.
Thank you.
Now we're going to bring up our very own Dawn Guile for Senate Bill 892. Senator Guile, I'm trying to find you. You have a panel. This is public health perimenopausal. Senator Guile has Sarah Kurtz, Ariana Kelly, LaShawn Stitt, Michelle Seary, and Tisha Edwards. It's interesting because your panel all says, 4 of your panel members say favorable with amendment.
Yeah.
Okay.
We'll explain. We'll explain.
Okay.
So we're going to talk about something that I'm sure my male colleagues on the committee are super excited to talk about. We're going to talk about menopause. All right, so Madam Chair, Mr. Vice Chair, Senator Hershey, Senator Kramer, for the record, Senator Dawn Guile, District 33 here to present Senate Bill 892. This bill is about something millions of women experience, and yet too many feel that they have to navigate alone, quietly, and often with unnecessary frustration. Perimenopause and menopause are not rare conditions. They are a natural stage of life that every woman who lives long enough will experience. And yet, for decades, our healthcare system has treated menopause as an afterthought. Under-researched, inconsistently taught in medical training, and too often minimized in the exam room. Over the past year, clinical understanding has continued to evolve. The FDA removed its long-standing black box warning on hormone replacement therapy after acknowledging that earlier data overstated risks, particularly for younger women. That shift reflects updated evidence and reinforces what many experts have been saying for years. Menopause care should be individualized and grounded in current science. But here's what we continue to hear from women across Maryland. They're exhausted, they're anxious, they're struggling with sleep, brain fog, heart palpitations, joint pain, depression. They are told this is just aging. They are handed an antidepressant without a broader conversation. They are forced to pay out of pocket because their insurance denies coverage for clinically recognized treatment. They are spending months, sometimes years, searching for a provider who is actually trained in menopause care. The frustration is not simply about symptoms. It is about not being heard. It is about feeling invisible at a stage of life when many women are leading companies, caring for children, aging parents, and serving their communities. They're often at the height of their professional and civic contributions, and yet they are being told to just power through. Since filing this bill, we have worked closely with Speaker Pena-Melnick. We understand that there's a similar bill that she has filed. The cross-file of this bill is Chair Heather Bagnall, and we're working to align those two House bills to ensure consistency across chambers. As amended, the bill focused on two practical targeted reforms. First, provider education. Health occupation boards that require a continuing education will grant enhanced continuing education credit for approved training on menopause evaluation and management. The Department of Health will identify appropriate programs in consultation with professional associations. This is about competency. Women should not have to educate their own clinicians about evidence-based menopause care. Second, insurance coverage. Insurers will be required to cover the evaluation and management of menopause and menopause-associated symptoms. This does not mandate a specific therapy. It does not create a new entitlement. It simply ensures that when a woman seeks clinically appropriate care, she is not denied coverage because menopause has historically been sidelined in policy. Menopause affects mental health, cardiovascular risk, bone density, workforce participation, and long-term economic security. When women leave their workforce early because their symptoms are unmanaged, that is not just a personal loss, it is an economic one. This bill says something simple but powerful: women's midlife health matters. On my panel today is some people that you may recognize, including one right here to my right, from being our colleague here in the Senate. I appreciate the partnership with the Maryland Commission on Women. I know we had Tisha Edwards was going to be joining us today, but I think that she may be out in the hall. We just went out of order.
Towards us.
She's running towards us, so she'll be here soon. In addition to Michelle Siri and just amazing women in support and leaders who are in support of this bill, and I appreciate their partnership. And with that, I respectfully ask for a favorable report on Senate Bill 892. Thank you, Madam Chair.
Thank you, Senator. Who's next?
We'll pass it right over there to Michelle.
Okay. Good afternoon, Madam Chair, members of the committee. Michelle Siri here on behalf of the Maryland Commission for Women. I'm very grateful for Senator Giles' support and leadership on this. Our commission chair, Dr. LaShawna Stitt, unfortunately had an emergency and had to leave, but I would encourage folks to read her testimony. And then I am really here to talk about why now is the time to pass this legislation. And so up until a few years ago, I can remember one time in my entire life when menopause was mentioned in pop culture. And it was an episode of Cheers when I was about 8 years old, when Carla went through the change. They didn't call it menopause, they just alluded to it, and they talked about how Carla became basically a demon. And it stuck with me. It was vague, it was euphemistic, but it left an impression because decades later, I remember that. And that is how, that reference really shaped how I looked at menopause for much of my life instead of this natural part of living. And that was the cultural norm. We've heard it's been under-researched, it's been under-discussed, it's been misunderstood, and now culture is shifting. Just recently, I went away for a weekend with a bunch of college girlfriends, and my teenage son asked me if we were all going to sit around, drink wine, and talk about cougarty. Cougarty is cougar puberty, for those of you that don't have 16-year-olds at home. And the answer was yes. My girlfriends and I were absolutely going to sit around and talk about cougarty because it was so powerful to have that community and have someone that understood what we were going through. But what I was really struck with was that my teenage son had language for this time of life and this health issue that never would have existed 30, 40 years ago. So menopause is being discussed now in the media, on social platforms, in workplaces, in the legislatures, and women are sharing those experiences and demanding care. And so I'm just here to say that if our culture is ready to have a word for it, we are ready to support it in many ways. And for those reasons, we would urge a favorable with amendments. Thank you so much.
Good afternoon. Thank you for having me. My name is Sarah Kurtz. I'm a nurse midwife, and I work for the University of Maryland. I'm here on behalf of the American College of Nurse Midwives. So for those of you who may not be familiar with what a midwife does, I care for women through the lifespan, not just when they're during their reproductive age, but through their entire lifespan. And I've been privileged to be a midwife now for 20 years. When I did my training, the full extent of my menopause training was that the physiology behind it, to reassure women that it was normal, and a few herbal supplements that might help their hot flashes and night sweats, because that was the short list of the symptoms that a woman would experience during menopause. This was in the wake of the Women's Health Initiative, so everybody had stopped treating their patients with hormones during that time. Patients were abruptly taken off of it, and there was no discussion or further research being done. I have spent many hours and conferences now trying to educate myself, and my new physician colleagues that are several years younger, only 5 or 6 years out of medical school, now have to come to me for advice and training, because even in the OBGYN field, these clinicians are not being trained in menopause care. And as you probably heard earlier, as she listed the symptoms that we now know are low estrogen symptoms, women are presenting to several different specialties, sometimes cardiology, sometimes psychiatry because of increased anxiety and severe mood changes, possibly even orthopedics because of bad joint pain. A lot of money is being spent on the workup for these when really it is a menopausal issue. So there needs to be better education of healthcare providers on what to look for, and to refer appropriately. Thank you very much for your time.
Thank you so much. It's so wonderful to be back here in the Senate Finance Committee, Madam Chair, Mr. Vice Chair, members of the committee. I'm Ariana Kelly. I now serve as the Executive Director of the Maryland Commission for Women. I really want to thank Senator Guile for her leadership on this initiative. It's so wonderful to have extraordinary partners in the Senate. And I will tell you, we also have an excellent partner on this, both in Chair Bagnall and Speaker Peña-Melnyk. Those of us on the panel just came over from the House hearing on the bill, and what Speaker Peña-Melnyk proposed was exactly identical to what Senator Guile is proposing. So language that is Senator Guile's bill, with the exception of the language in Speaker Peña-Melnyk's bill that takes what was Senator Guile's study on insurance and replaces it with the insurance language. The reason she can do that is because she actually requested the Healthcare Commission do the study that we're asking for during the interim, and she has that information. So with that, you will know that at the House hearing, the League of Life and Health Insurers had no position. Aaron Hopwood testified to that. They were okay with the language in the Speaker's bill. And we also heard from MDH in support of this Speaker's bill, with the addition of the language in Senator Giles' bill. So it's a little complicated procedurally, but again, what Senator Giles is proposing will result in the same proposal that the Speaker has. And with that, I will say that the most important thing I want to point out to you all is that the study language in this bill that the Maryland Commission for Women would do is, I think, incredibly important. We are excited to do that work. You heard from Commissioner Seary. Unfortunately, Commissioner LaShawn Stitt had to leave. However, the Maryland Commission for Women is really committed to working not just in the short term, but in the long term to figure out how we can support women and their economic stability. They're an essential part of the workforce, and there's a lot of work to do in that space, so we're eager to do that report in partnership with other state agencies, which is what we like to do at the Commission for Women. So with that, I urge a favorable report to this bill as amended, and I'm very, very thankful for this committee's leadership to advance women's health.
Thank you. So if I understand, the study has been done, and that's what we're going to amend in Senator Giles' bill. Is we're not going to be requesting a study in her bill.
Correct. It would
And
have the
other than
language
that-
for the insurance requirement.
Thank you. And other than that, the two bills will be identical then.
Yeah, go ahead. Yeah.
So there is, I think, a little bit more language in the clinical training. The Speaker's bill has a couple of additional lines that directs the health occupations boards to identify a training program. So it's minor language in that section that's different. But the premise in Senator Giles' bill, which is you get credit for 2 hours for doing menopause, is in the Speaker's bill. So that, yeah, right.
Well, they both match, so they'll go through quickly. Thank you very much. It's nice to see you, Senator Kelly. Senator Kramer?
Thank you, Madam Chair. Senator Guile, I wanted to share with you that during your presentation, I received a text message from my wife, and she asked me to share with you that I will be moving favorable as soon as the bill is introduced in committee. I will be voting yes, and she said, thank you for introducing the bill. So just thought I'd share that with you.
Thank you. I appreciate her support.
It helps you too, Senator. You just don't know. That ends the hearing on Senate Bill 892. So Senator Gile, if you can stay, we're going to do Senate Bill 562. I'm looking for it so I can call the panel up. Jumping all over the place. Okay, so Senator Gile, this is your State Board of Pharmacy prescriber pharmacist agreements. You have Matthew Shimoda, Emily Keller, and Dr. Jasmine Ebron on your panel. Very good. Thank you.
Good to see you. All right, good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. For the record, Senator Dawn Gile, District 33, here to present Senate Bill 562. This bill strengthens Maryland's response to opioid use disorder by expanding access to medication-assisted treatment through structured prescriber pharmacist agreements. Although overdose fatalities have decreased in recent years, opioid use disorder remains a serious public health challenge. In many communities, both urban and rural, access to addiction specialists remains limited. Senate Bill 562 authorizes pharmacists under strict safeguards to participate in agreements that allow treatment of opioid use disorder using controlled dangerous substances. The safety standards are rigorous. Participating pharmacists must register individually with the DEA and Maryland's Office of Controlled Substances Administration, complete required training, operate under written protocols with a prescriber, and query the prescription drug monitoring program before initiating or modifying therapy. This ensures comprehensive oversight and compliance. The Maryland Board of Pharmacy has expressed support for this legislation, emphasizing that it expands access to life-saving medication-assisted treatment while maintaining strong regulatory protections. The bill also streamlines administrative requirements by centralizing agreement submission to the Board of Pharmacy, reducing unnecessary barriers for physicians who wish to participate in collaborative treatment models. The sponsor amendment clarifies the licensed certified midwives are recognized within the authorized prescriber framework. This is a measured expansion of access, not an unstructured expansion of scope. And for these reasons, I respectfully request a favorable report on Senate Bill 562. Go ahead.
Good afternoon, Madam Chair. Thank you, Senator Giles. And good afternoon to the other members of the committee. My name is Dr. Jasmine Ebron. I am a board-certified, residency, and fellowship-trained pain management clinical pharmacist with a subspecialty in addiction medicine. Today, I'm testifying in support of Senate Bill 562. Improving access to treatment for opioid use disorder is a national public health priority, and at least 10 other states have permitted pharmacists to prescribe under controlled substances, have permitted pharmacists to prescribe controlled substances, including buprenorphine under collaborative practice. Pharmacists are uniquely positioned to support buprenorphine management through monitoring for efficacy, safety, adherence, and diversion while providing comprehensive medication education. The literature consistently demonstrates that pharmacists' involvement improves patient outcomes, reduces healthcare costs, and decreases physician burnout. Pharmacy schools and residency programs have prepared pharmacists to deliver high-level patient care in both inpatient and ambulatory care settings, equipping them to meet the complex demands of opioid use disorder management. Initiation of buprenorphine therapy can require 2 to 3 hours for the initial visit, often followed by multiple appointments within the next couple weeks to safely titrate the dose. The maintenance phase may be achieved within weeks. However, patients require close monitoring for relapse and diversion. Maintenance treatments commonly continues for months to years, and when discontinuation is appropriate, careful tapering is necessary and may extend over several months. By supporting this bill to permit physician-pharmacist collaborative agreements, you are reducing barriers for patients who cannot afford to wait weeks for their physician appointment. Thank you.
Who's next?
Good afternoon, Chair Beidle and Vice Chair Hayes and members of the Finance Committee. My name is Matthew Shimoda. I'm today here in the capacity as a Board of Pharmacy Commissioner on the Maryland State Board of Pharmacy. Although I'm Dean at Notre Dame of Maryland University School of Pharmacy and Health Professions, my views today will be not necessarily reflected by my employer. Senator Gile really did lay out for you what the intention of this bill is. This legislation addresses 2 critical needs in our efforts to treat opioid use disorder. One is the streamlining of the administrative processes, and 2, optimizing and expanding access to these life-saving treatments for opioid use disorder as well. Senate Bill 562 simplifies that administrative process by requiring only the pharmacist to submit the agreement to the Board of Pharmacy for approval. This therefore reduces the red tape for physicians, making it easier for them to engage in this team-based healthcare with pharmacists that benefit from these patients will benefit from these services. More importantly, this bill empowers pharmacists to play a frontline role in addressing the opioid crisis. This bill only allows pharmacists to meet specific criteria, including holding a degree from the Doctor of Pharmacy, individual registration with the DEA, and the Maryland Office of Controlled Substances Administration. We can enter into these agreements using controlled substances as therapy, as you heard from Dr. Ebron, and you'll hear from Dr. DePaula shortly. We know that pharmacists often are the accessible point in healthcare that will service those communities and underserved patients, mainly in the rural areas of Maryland. By allowing us to manage and modify these therapies under strict protocol, we will be better positioned to meet patients where they are in addressing this crisis. The board wants to emphasize that this expansion comes with rigorous standards. Mandatory PDMP checks. Every pharmacist must request data before prescribing through the PDMP. These standards will be held through the Board of Pharmacy, and I would respectfully ask for a favorable report on Senate Bill 562.
Good afternoon, Madam Chair, members of the committee. My name is Emily Keller. I serve as the Special Secretary of Overdose Response. I'm here today in support of Senate Bill 562. Preliminary data shows that 1,315 Marylanders died of a drug overdose last year, and 1,026 of those deaths were related to an opioid. While Maryland has made significant progress in recent years in reducing overdose deaths, including that 26% decrease from 2024 to 2025, there are still ways that Maryland can expand efforts and build upon these positive results. Medications for opioid use disorder, or MOUD, are considered the gold standard for treatment. Buprenorphine is one of the 3 FDA-approved MOUDs, and it works by reducing withdrawal symptoms and cravings experienced by people with opioid use disorder. However, access and utilization of buprenorphine in Maryland remains limited. One way Maryland can help increase access is by empowering pharmacists to treat patients with OUD with buprenorphine, especially since pharmacies are often easier to access for patients compared to doctors' offices and other medical settings. Maryland law currently authorizes pharmacists to engage in prescriber-pharmacist agreements to treat a variety of health conditions. However, current law does not explicitly state that pharmacists have the authority to use CDS to treat patients via a prescriber-pharmacist agreement. This bill provides a framework by which pharmacists can achieve that outcome, and it does this in a thoughtful manner, requiring pharmacists to register with the DEA and the Maryland's Office of Controlled Substances Administration, to complete any training required by federal and state law, and to follow a protocol established by the prescriber. Increasing access to buprenorphine in Maryland is absolutely vital in saving lives and supporting people in recovery, and this bill would help us do just that. For those reasons, I respectfully ask a favorable report. Thank you.
Thank you.
Thank you.
Horton?
Good afternoon, Aaliyah Horton, Executive Director of the Maryland Pharmacists Association. I'm just really happy today. This is like the easiest day I've had to sit, but very happy to have such great pharmacists here to talk about the work that they do and really highlight that pharmacy is not a monolith and that the members of MPHA in our community really expand access and create access to care in so many communities and in so many different ways. And with that said, we are in favor of this bill, and my understanding is that there's no opposition, or at least there wasn't on the other side, that there was no opposition, and that we're happy to support the bill. Thank you.
Well, it's interesting because Ann Seacott's partner, Robin, is going to testify favorable with amendment. So it's not quite opposition, but.
Yeah, and I will mention that we are fine with that amendment as well.
Thank you, Madam Chair, members of the committee. Ann Seacott wearing different hat, wearing the hat for the Maryland National Council on Alcoholism and Drug Dependence, the Maryland chapter, as well as the Maryland DC Society of Addiction Medicine, both in strong support of the bill. You've heard from folks as to all the technicalities of how this will work, and we really do believe that greater access to medication will continue to help decrease the overdose death rate that we're experiencing in Maryland. So we fully support the bill. Thank you. And I think everybody's okay with that amendment, too.
Okay. So I don't see any questions. Thank you both for your testimony. And Robin, are you here? Uh-oh.
She's in the hallway.
Is she?
Okay.
Let's see if we have it in writing. Maybe we have.
It is in writing.
We do have the amendment in writing. We can. Okay, we have a request in writing. Thank you very much. And we have one virtual Bethany DePaula from University of Maryland School of Pharmacy.
Hi, can you hear me?
We can hear you. Thank you.
Should I start?
Yes, ma'am. Please start your
Okay,
testimony.
hi. I'm Dr. Bethany DePaula. I am... Yes, can you hear me?
Bethany, if you have the YouTube on, you need to mute that. There's an issue. You have something else in the background.
I see. Hold
You were
on.
probably watching while you were waiting.
Yes, can you hear me now?
We can hear you, yes.
Okay, I closed it. Sorry for the tech problems. Hi, I'm Dr. Bethany DePaula. I am a residency-trained board-certified psychiatric pharmacist. I'm a professor at the University of Maryland School of Pharmacy, and I'm a consultant for the Maryland Addiction Consultation Service, although I'm representing my own views today. I have been practicing under state board-approved collaborative practice protocol since 2013, including an opioid use disorder protocol. And I've practiced actually in 3 separate settings. The patient population I practice with are generally underserved. They're patients with psychiatric and substance use disorders, and I've practiced at an FQHC, a health department, and I currently work at a small medical group that is co-located with residential treatment programs for patients with substance use disorders. And I work collaboratively with the team with physicians and nurse practitioners providing medication management services. I think this is a very important bill for a couple of reasons. First of all, it does not change the pharmacist's scope of practice, but it does allow us to more effectively operate at the top of our license. And that's by reducing a lot of the administrative barriers that some of our other speakers have already mentioned. Secondly, it actually gives us an opportunity to register. We can currently register with the DEA, but there is no path for us to register with the Maryland OCSA right now. And this bill will allow us to do that, which actually increases safety and oversight. And then finally, I think we can all agree that we're really experiencing a significant opioid crisis, and it is all hands on deck as far as efforts go. As a faculty member, I train pharmacy students. I'm a residency director, so I train our pharmacy residents. And I am losing residents every year because they can't practice effectively under collaborative practice. And this bill will help to change that. So I request that you have a favorable approval for SB 562. Thank you very much for your time.
Are there any questions? Seeing none, thank you so very much for your testimony on this bill. That ends the bill hearing on Senate Bill 562. Next, we're going to hear Senate Bill 39 by Senator Lamb, Behavioral Health Certified Community Behavioral Health Clinics and Outpatient Mental Health Centers. We have panel members Marshall Henson, Stephanie Slowly, Carrie Guthrie, and Nicole Granner.
All right, thank you, Mr. Vice Chair. It's going to be a super exciting bill. While I wait for my panel to come up.
You may begin when you're ready.
All right. Oh, they're coming. Okay. All right. Why don't I start while the rest of the panel convenes here at the table. Good afternoon, members of Senate Finance, Vice Chair, and here to testify and introduce Senate Bill 39. For the record, Clarence Lamb, Senator in District 12. Before I start, I want to point out that there is an amendment to the bill that takes significant portions out of the bill. So it aligns this bill to match our cross-file, which is HB 772. This bill was pre-filed, which is why there's such a significant amendment to it. There is a reprint of the bill as amended in your bill folder, so you can find that online as well. That should also address the significant fiscal note that you saw attached to this bill. This removes all of that, so it should address the fiscal note for the bill. So since their origins of certified operations back in 2018, certified community behavioral health clinics, or CCBHCs, have been an essential part of Maryland's public health system. They've been helping to improve access, addressing care coordination, and overall community health outcomes improvement processes. Similarly, the outpatient mental health centers, or OMHCs, have been central to expanding access to those who could not easily afford it in the behavioral health systems. However, both certified community behavioral health clinics and outpatient mental health centers face a crisis of funding that has a real impact on our state and also surrounding communities. The outpatient mental health centers are still only weakly sustained by outdated reimbursement methodologies that do not reflect the changing and evolving nature of service delivery. For example, in Frederick County, the OMHC there closed last summer after 90 years of service to the community, precisely due to expenses that were superseding reimbursements in order to keep their doors open. On the certified community behavioral health centers side, clinics are aging out of their pilot programs and deserve a rate methodology that reflects their performance in the state. As amended, and the amended version reprint is in your bill folder, SB 39 will establish a work group to develop transparent, cost-based, and community-driven reimbursement methodologies for both certified community behavioral health centers as well as outpatient mental health centers. It will do this through reviewing cost drivers and other state actions, identifying barriers to implementation, as well as proposing final methodologies. The work group will contain key actors in the public health space, such as the Maryland Healthcare Commission, MHCC, the Maryland Medical Assistance Program, the state's Behavioral Health Administration, and other stakeholders such as hospital associations and health advocacy organizations. As the current reimbursement rates fail to support our public health institutions, threatening more closures such as the one in Frederick County, the imperative is to establish rate methodologies that keep CCBHCs and OMHCs running to be able to continue to provide this crucial service to Marylanders in need. So I ask the committee to consider a favorable report in this bill, SB 39. Happy to turn over to other members of this panel and to take questions at the end. Thank you.
Good afternoon, Vice Chair Hayes, members of the committee. My name is Nicole Grainer, and I'm the Public Policy Director for the Community Behavioral Health Association of Maryland. CBH represents 95 community-based providers across the state, including OMHCs and CCBHCs, serving individuals in Maryland's public behavioral health system. As our sponsor mentioned, Senate Bill 39 is the intended cross-file for House Bill 772. Amendments have been prepared to align those two bills, and we are strongly supportive of those amendments. Through the HOPE Act, Maryland law has required an independent cost rate study for community behavioral health services since 2017. That work is now underway, and we do appreciate the department moving that forward. Senate Bill 39, as amended, builds on this effort. The HOPE Act required a cost study. This bill strengthens the structure around how rates are set. It formalizes provider participation. Consultation is not the same as participation. Providers need a seat at the table when methodology is shaped, cost drivers are identified, and implementation options are evaluated. Policy ideas may look reasonable on paper, but unintentionally destabilize systems in practice. This bill ensures operational realities are part of the analysis from the start. It also ensures independence and transparency. Rate setting affects whether providers can sustain services and whether Marylanders can access care. Housing this work within MHCC strengthens confidence in the final recommendations. Senate Bill 39, as amended, directs the work group to use cost data already being collected, including the CCBHC cost reporting tied to the demonstration application to guide its work. So this is not a separate process and does not delay moving CCBHCs forward. Modernizing rate methodology is about aligning payment with the cost of delivering care and creating a process all stakeholders can trust. CBH respectfully requests a favorable report on Senate Bill 39 as amended. Thank you.
Good afternoon, Vice Chair Hayes, committee members. I am Carrie Guthrie, the president and CEO of Cornerstone. We are one of the original CCBHCs in Maryland, supported with SAMHSA grant dollars. We provide services across the continuum of care, from residential to outpatient mental health clinics. Cornerstone's experience demonstrates the devastating impact of a lack of rate methodology. Since Cornerstone took over 3 of the Montgomery County OMHCs in 1999, we have budgeted annual losses up to $1 million for that program. One of the reasons that Montgomery County privatized their clinics was the Medicaid rates could not support the county's salaries, and they could no longer afford to do it. OMHCs are our most costly service because of the cost of the licensed providers that are required. We have not been able to match salaries with many of our competitors, losing candidates and staff to government, schools, and hospitals. But we continue to provide these services because they are key to our mission, and we count on other service lines to make up the loss. The problem with that is, over time, you impact the stability of the entire organization with ongoing deficits. What has that meant for Cornerstone? It means that we have had turnover as high as 40% while coming out of COVID. It means that we have closed intake of new clients because we do not have the staff to serve them. While other positions are filled in less than 30 days, the clinic license positions often take over 3 months to put in place. It also means that we have had to purposefully shrink 3 programs' capacity: ACT by 100 clients, residential crisis by 8 beds, and behavioral health homes by 250 clients, because we did not have the staff to provide these services. Rate setting for CCBHCs and OMHCs can stabilize workforce, access to care, quality of care, and sustainability of care. We respectfully request a favorable report on SB 39 with the proposed amendments. Thank you.
Good afternoon, Vice Chair Hayes, members of the Senate Finance Committee. My name is Marshall Henson. I'm the Vice President and Chief Operating Officer with Shepherd Pratt for Community Services. I want to thank you for the opportunity to provide testimony today. This bill creates a behavioral health rate methodology modernization work group within the Maryland Healthcare Commission. Across our 380 sites of care, from our OMHCs and CCBHCs to crisis services, inpatient hospital care, residential programs, and school-based mental health, we see the same challenges every day. Maryland's outdated and non-transparent rate methodology makes it increasingly difficult to deliver timely, high-quality outpatient behavioral health care. The amended version of SB 39 provides a practical, data-driven solution. The bill establishes a structured work group within the MHCC that finally brings together providers, state partners, and system experts to modernize the rate-setting methodologies. Importantly, it builds on the cost studies already underway. It examines real cost drivers like staffing, supervision, regulatory requirements, and geographic variation. This matters because outpatient care is the backbone of the Maryland behavioral health system. OMHCs and CCBHCs particularly need attention regarding rate setting, as both models currently operate under fundamentally different reimbursement approaches, even though they share the same workforce, regulatory obligations, and clinical needs. This fragmentation has led to misaligned incentives, operational inefficiencies, and barriers to same-day access. Most urgently, we cannot stabilize Maryland's behavioral health workforce without reimbursement rates that reflect the true cost of care. For these reasons, we respectfully urge you to provide a favorable report on SB 39. Thank you.
Good afternoon, Vice Chair Hayes and the members of the Senate Finance Committee. My name is Stephanie Sully-Little, and I serve as the Executive Director for NAMI Maryland. We are in strong support with amendments for SB 39 because we know that it ensures that rates will reflect the true cost of employing capable teams to do quality care. And modernizing these rates ensures that providers remain viable. For NAMI Maryland, who represents 60,000 individuals, families, and loved ones, it means that there's somewhere that they can go who will see them, and it matters. In the United States, 1 in 5 adults have mental health illnesses, yet fewer than half of them receive treatment just in the past year. Outpatient mental health centers offer a range of services to address various mental health conditions. It's designed for individuals who need support to manage their mental health challenges in a flexible, cohesive way. CCBHCs are required to offer a broad range of coordinated evidence-based services for people who are living with mental illness and substance use disorders. CCBHCs have shown to improve the access of comprehensive range of care, treatment, and recovery supports, and NAMI supports these expansions. By providing a well-rounded community care, CCBHCs have helped people with mental illness stay well and engage in their communities. Mental health providers are routinely paid less than other providers, and NAMI Maryland really does support the increasing of provider reimbursement rates because it matters. If they don't have quality providers, they don't get quality care. If they don't get quality care, they don't stay. And so we need to do that. For those reasons and so much more, we strongly support SB 39 with the proposed amendments. Thank you for your time.
Excellent, thank you. Are there any questions of this panel? Seeing none, thank you so very much. We have two people signed up favorable with amendments. That's Andrea Mansfield and Lauren Graziano. Is Lauren here? Lauren Graziano? Nope. Okay, it's all on you, Andrea. How are you?
Okay. Mr. Vice Chair, members of the committee, Andrea Mansfield with Manus Canning and Associates, representing the licensed clinical professional counselors of Maryland. Also in strong support of this legislation with amendments. As you probably know, Maryland already does suffer from a shortage of behavioral health providers, and my client really sees this bill as a way to strengthen that and actually help address that workforce shortage by ensuring that there are good, stable reimbursement rates, and also to assist providers in addressing the administrative struggles within their offices. The licensed clinical professional counselors also provide needed comprehensive mental health care services to individuals in crisis, just like representatives that were on the previous panel. Some of them actually work in those same settings. Those that do not, but also struggle in the same way as they are single or small practitioners, and they do have problems making ends meet, just like the others, and struggling within their offices. It really sees this approach as by examining the rate setting and the reimbursement methodology across a full spectrum of providers will provide for equity. We'll professionalize the services that this profession provides, also expand the number of providers out there and improve access to care for those that need these much needed services. With that, the clinical professional counselors are respectfully requesting that the amendments also include independent outpatient providers and one representative of the licensed clinical professional counselors actually on this work group to look at the methodology and come up with recommendations for the rate setting that we support with amendments, and happy to take any questions.
Are there any questions? No. Seeing none, thank you so very much. This ends this panel and the bill hearing on Senate Bill 39. Next, we will hear from Senator Kramer for Senate Bill 663, Nursing Homes Direct Care Wages and Benefits and Cost Reports. On the panel, we should hear from Bridge DeMays, Megan Peters, Sam Williamson, Sarah Westrick, and Kaylee Grummitz. Hopefully I didn't butcher that too bad. Welcome, welcome, welcome.
And good afternoon to you, Mr. Chair, and colleagues. I will share with you that in my time here in the legislature, an important focus of the work I have done is surrounding seniors' protections, ensuring that we are the most hospitable state in the nation to ensure our seniors are in fact protected, helping them stay in their homes, and when they can't stay in their homes any longer, that the facilities where they reside are the safest in the nation. And as you're well over the last couple of years, I have directed my attention to nursing homes and nursing home conditions as an important part of that work. And I will note, colleagues, we have an incredibly diverse panel that is here today. And the reason for that is this wide array of interest to ensure that we are doing right by our most vulnerable residents who do reside in nursing homes. Senate Bill 663 is about one simple principle. When taxpayers fund nursing home care, those dollars should go to resident care. Today, roughly 66% of the nursing home industry's $140 billion in annual revenue nationwide comes from public programs, primarily Medicaid and Medicare. In Maryland, our Department of Health's 2025 report on nursing home costs, produced pursuant to last year's bill, analyzed cost reports from 221 facilities participating in the Maryland Medical Assistant Program. It found, and this is a staggering statistic, colleagues, it found that only 53.86%, barely over 50% of the $3.4 billion in reported comprehensive care revenue was allocated to the direct care workforce, barely over 50% of revenues. 83% of nursing home residents come directly from hospitals. Their situations are medically complex. They are frail. They require stable, skilled staffing. And when facilities are short-staffed, when wages are low, and when resources are diverted away from bedside care, the result is predictable: diminished quality and avoidable hospital readmissions. Senate Bill 663 establishes a reasonable spending threshold that ensures revenue is directed toward resident care and the direct care workforce. It improves fiscal transparency and strengthens oversight so we can see clearly how our public dollars are being used. This bill does not micromanage operations. It simply sets guardrails to ensure that taxpayer investments prioritize care over profit extraction. Other states have already recognized this responsibility. In 2022, Massachusetts implemented a 75% direct care cost quotient requirement. In 2021, New Jersey enacted, colleagues, a 90% direct care revenue requirement. And that same year, New York mandated that 70% of operating revenue be spent on resident care, but they actually, in New York, capped profits at 5%. Maryland should not lag behind when it comes to protecting vulnerable seniors and people with disabilities. We cannot protect residents if we can't see where the money goes. We cannot address chronic understaffing if revenue intended for care is siphoned elsewhere through related party transactions or complex ownership structures, which is very commonplace within this industry, that the nursing homes will have entities that own the property or that have management systems, and they feed revenues off into those affiliate organizations, giving the impression that their profits are far less than they actually are. Today, 81% of nursing homes are for-profit. Many are owned by large chains, and many by out-of-state private equity investors. When public dollars dominate revenue streams, public accounting must follow. Senate Bill 663 ensures transparency, it strengthens oversight, and most importantly, it prioritizes bedside care. The nurses, the aides, and the staff who make the difference that provide dignity to our most vulnerable populations. This legislation is not about punishing responsible operators. It is about setting clear, reasonable standards that align public, once again, colleagues, public funding with public purpose. Our nursing home residents cannot advocate for themselves. That's why it is our responsibility to ensure that the dollars intended for their care are actually used for their care. This is simply about ensuring we are providing for people over profits. Colleagues, there's a one-word amendment that I believe is in possession of the committee. Finally, to address the fiscal note, which is not overly significant, I do want to point out that the Department of Health already has a private contractor doing much of this work, and it's very likely they could simply expand the contract for that work to incorporate the requirements of this bill and at a significantly reduced cost than actually hiring people within the department. And then I would also like to point out that in some of the opposition from my friends who will be up shortly, they're bemoaning certain reporting requirements in the bill, but those reporting requirements already exist. They exist under regulation. We are simply codifying those requirements. And with that, I'm turning it over to the panel, Mr. Chair. Thank you.
Good afternoon. I am Bridge Dumais with 1199, representing nearly 4,000 members who work in long-term care facilities across Maryland. We urge a favorable report on SB 663 because investing in workers is crucial to providing high-quality care. Before we dive deeper into what this bill will do, let's look at the landscape of skilled nursing facilities, SNFs, in Maryland. One, we have a disproportionately high turnover rate in ownership, which leads to lower quality of care. CMS data shows that 84 facilities had either 1 or 2-star ratings, and of those, over 50 of them were part of chains. 2, for-profit chains now make up a significant portion of the industry. Only 17% are nonprofit. 3, the industry has many operators that are either connected to private equity or who model their business practices after private equity, like hiding profits in related party transactions. SB 663 places much-needed guardrails against bad actors. Let's walk through what SNFs would actually be required to do with this bill. I have here in my hand a copy of the Massachusetts Direct Care Cost Quotient that this bill is modeled after. As you can see, it is only 2 pages. It includes all positions, including dietary and housekeeping. It is very simple. It does not duplicate current cost reports, and it clearly lays out how much each SNF spends on their workers. I have printed copies here for each of you to review. Massachusetts has set a 75% threshold and faced little industry outcry. It was collaborative because transparency about how public funds are spent is a best practice, and their model is working. Over 80% of nursing homes in Massachusetts are meeting or exceeding the 75% threshold. 1199 is happy to connect the Maryland Department of Health with regulators in Massachusetts to ensure a smooth implementation process here in our state. Vote yes for transparent stewardship of Medicaid dollars, protecting quality care, and addressing the short staffing crisis. Thank you.
Good afternoon. My name is Sam Williamson, and I'm a lawyer with the Public Justice Center. I'm here to support SB 663. Average nursing staff turnover in Maryland, in nursing facilities overall, is 49.3% per year. This staffing crisis is harming residents. Studies show that staffing instability leads to more short-term residents failing to improve enough to go home, and long-term residents have less independent mobility and are less able to do their basic activities of daily living. I have talked with residents who have told me they've been left in soiled beds for hours. Many people have told me they're afraid that they're going to die because there aren't enough staff to respond to their call bells. SB 663 would require 75% of nursing facility revenues to be spent on direct care worker wages and benefits. This would attract and retain more staff in a sector where over 1/3 of certified nursing assistants currently have to rely on public assistance to make ends meet. Nursing facilities can afford to pay their direct care workers more. Based on cost report data, nursing facilities have good profit margins. Their margins are better than the average for all healthcare facilities. But profits are even higher than what is shown in the cost reports. 75% of nursing facility owners pay money in related party transactions, essentially paying themselves. Owners frequently create separate LLCs to charge rent, pay management companies, insurance, and other costs, and then they overpay those costs, sometimes by up to 1,200%. The nursing facility industry spends billions of dollars on related party transactions every year. These transactions skew the data, making the facilities look less profitable than they really are, while squirreling away large amounts of profit. It's time for Maryland to create a wage pass-through, ensuring that workers are not left behind, struggling to make ends meet, while owners pocket millions of hidden dollars. For these reasons, the Public Justice Center urges a favorable report on SB 663. Thank you.
To Madam Chair and members of the committee, my name is Rhonda White. I am a certified medicine aide at a long-term care facility and a union delegate for 1199. I support the Nursing Home Staffing Crisis Funding Act because it could help the staffing crisis by requiring 75% of Medicaid dollars to be spent on direct care. This will improve working conditions for employees and quality of care for our residents. In my facility, we have 1 GNA to 20 patients. We provide high-quality health care, but can't be everywhere at once. This is bad for residents and for workers too. When we don't have proper staffing, our health suffers, then workers burn out and short staffing gets worse. I care about my residents. It is heartbreaking for workers when we can't give them everything they need to live with dignity. For examples, I had a resident that needed immediate assistance with dressing, but he had to wait over an hour until someone was available to help him. Residents pay for service that are not being rendered in a timely manner due to short staffing. They deserve so much more. I work hard, I pay taxes, and I want my tax dollars to go where they're supposed to go. In the case of Medicaid, that means patient care. That is why we need this bill. With the upcoming federal cuts to Medicaid, it is more important than ever that we have a guardrail for how public funds are spent in Maryland. Please vote yes on this bill. Thank you.
Good afternoon. My name is Winston Robinson. I work in the kitchen at a long-term care facility in Baltimore County. My department works short-staffed at least once a week. When my department is short-staffed, we have a lot of extra work. That leads to frustration for the residents and workers. Meals don't go out on time when we are short-staffed, and that is bad for the resident. They need consistency in their meals for their health and the medication schedule. Family members get frustrated as well. That is challenging to deal with. My department isn't the only one that works short. JNAs often caring for 32 patients with only 1 GNA on the floor. Even when the meal goes out on time, the GNA are short-staffed and can't distribute the meal. They are sent back to the kitchen. We must throw away that meal, and the patient don't get a meal until the next scheduled meal. We need you to pass this bill because the people doing the work in nursing homes are underpaid, underappreciated, and overworked. With this legislation in place, it would make sure that funding for direct care is used for improving residents' lives and our working condition. Hopefully, when this bill is implemented, management will hire more workers. I work in long-term care because I love to serve the resident. When I cook a proper meal, I can help people live a better life. Our residents deserve the best. They have lived and worked their whole lives. Now it's time for them to be cared for. Please help me be successful in doing the work I love by voting yes on this bill. Please, thank you.
Good afternoon, Vice Chair, members of the committee. My name is Megan Peters. I'm the Director of Government Affairs for the Alzheimer's Association, here in support of Senate Bill 663. As of 2025, an estimated 46% of residents in our nursing home facilities are living with Alzheimer's or another dementia. For these residents, direct care workers are essential. Not only are they helping people with the most basic parts of their daily life, but they can bring comfort and stability to people living with dementia. Because of this, a stable and supported direct care workforce is a key element to overall well-being. When staffing is stretched, routines can break down, residents with dementia can become disoriented, anxious, or at a higher risk of complications. And we know that Maryland will need more workers in the years ahead as our population ages, more people are living with dementia, and even more live with multiple chronic conditions. Senate Bill 663 helps Maryland prepare for this future by adding reasonable, targeted transparency around how nursing homes use resources intended for care. This transparency is essential for our residents living with dementia who have high and complex care needs and often cannot advocate for themselves. It helps ensure that resources are directed to the hands-on support they depend on every day. Senate Bill 663 also helps protect families from bad actor facilities by shining a light on spending practices. This visibility supports appropriate oversight and helps ensure care remains centered on residents. For these reasons, we urge a favorable report. Thank you.
Are there any questions of this panel? Seeing none, thank you all so very much.
Thank you, Mr. Chair.
Indeed. Now, earlier I called Sarah and Kaylee, but I got Rhonda and Winston. Is Sarah and Kaylee still here?
Sarah's in another hearing.
Okay. And what about Kaylee? I'm right here. Sherman. Okay, excellent. You may proceed when you're ready.
Thank you, Vice Chair Hayes, members of the committee. My name is Callie Shumatz. I'm with the Maryland Center on Economic Policy. So long-term care workers are a vital part of the social infrastructure that keeps Maryland going. But today, the state struggles to meet the need for those workers. SB 663 would improve both access to care and quality of care in Maryland nursing homes by requiring that at least 75% of these facilities' revenue goes toward care. Sufficiently staffing Maryland's nursing homes becomes more urgent each day. The state's population over 65 grew by 34% from 2014 to 2024. And it's projected to grow by another 23% by 2035. We can only meet this need if nursing homes use their resources to hire and pay direct care staff. But in 2024, Maryland nursing homes that received Medicaid funding only spent 54% of their revenues on direct care wages. Meanwhile, data from the Centers for Medicare and Medicaid Services shows that about 18% of Maryland nursing homes have serious quality issues. The 75% standard under SB 663 could translate into increased hiring or higher wages. In practice, these go together because paltry wages are among the top barriers to recruiting and retaining a sufficient long-term care workforce. Direct care workers in Maryland nursing homes typically took home less than $32,000 in 2023, meaning they're too often not paid enough to afford housing, food, and other basics. More than 40% receive public assistance to help meet their basic needs. And as others have mentioned, Senate Bill 663 would also put Maryland in good company as policymakers have enacted similar standards in New York, in New Jersey, Massachusetts, and New York. So for these reasons, we'd ask for a favorable report. Thank you.
Thank you. Are there any questions? Seeing none. We do have a panelist of unfavorables, Allison, Aaron, and Dana. All right.
Allison couldn't be here today, Mr. Chairman.
Excellent. That saved us another 2 minutes. Thank you. You all may proceed whenever you're ready.
Good afternoon, members of the committee. My name is Dana Kaufman. I'm here today on behalf of Lifespan Network, and unfortunately, we do oppose this bill. I just want to, there's a lot said, so I'm going to try to address some of it. As far as the transparency piece, I want to make it very clear. It seems like this might be a different cost report, but Maryland does already in regulations have a very significant cost report that has to be filled out. 204 nursing facilities are required to fill it out. 204 did submit, 204 required, 204 submitted it. If you do not submit that cost report, you are subject to having a 3% decrease in your per diem rate every month, and after 6 months, the department will stop paying you. So that is a form that is timely filed all the time. It is also subject to inspection and audit by the Maryland Health Department. They have a contractor, Myers and Stauffer. So again, as far as being able to see exactly where the money goes, it is in that cost report. Now, to go back to the cost report and financing for nursing homes, we have a very complicated formula. I do not know, and I cannot address those other states because I don't know how Massachusetts and New York actually do their calculations and how that compares to Maryland and how that compares to Maryland's funding. Nursing homes have not received a rate increase for the last 2 years. But just to let you know, there are 5 cost centers that make up this cost report. It's nursing, other patient care, routine administrative, capital property services, and rental. And each of those actually do have staffing components in them. I know that we are talking about, as the bill says, only nursing, dietary, respiratory therapy, and social work. But what's not included here is all of those other salaries that make up direct care. With that, I am done. You have my written testimony, and I'm happy to answer some additional questions.
Mr. Chairman, members of the committee, Aaron Greenfield on behalf of Leading Age Maryland in opposition to Senate Bill 663. Of course, we support increasing wages for nursing home workers, but this bill is not the vehicle. We aren't aware of any link between a 75% wage threshold and the quality of care. Multiple Maryland providers reported spending 50 to 74% of revenue on direct care wages, yet still achieved a 5-star CMS staffing ratings. We also, which Ms. Kaufman touched on, would urge a broader definition of direct care. I think the bill's wage pass-through mechanism excludes many essential roles such as housekeeping, maintenance, clinical leadership, and admin staff who directly support resident care and operations. And because these roles are excluded, providers simply cannot realistically meet the 75% threshold. I also think it's important to note the sponsor brought up the cost report study from last year and the 53.86%. Which is interesting because our read of what went into that 53.86% is very different than what's in this bill, and the numbers don't match up. So if you were to look at the entire landscape of including some of the other categories of work, you might reach that 75%. So I think that cost report study is a little limiting in the categories it reviewed. And then finally, we also agree that there's punitive enforcement in this bill that could end up reducing important access to care. For those reasons, and you have my written testimony, we respectfully request an unfavorable report.
Excellent. Thank you for your testimony. Are there any questions of this panel? Senator Kramer.
Thank you, Mr. Chair. Dana, Aaron, I appreciate both of you. You do great work, and I'm not surprised to see you here in opposition. You're representing the industry that is affected by this proposed legislation. Dana, I think out of the gates you acknowledge there's already a cost report. Mm-hmm. Is that in regulation?
Yes, it is. If you look at my written testimony, I have the site for Comar in my testimony. It's very extensive, the requirements.
So this is simply taking, in theory, that extensive reporting and putting it into statute. So in reality, the change for your client is minimal to non-existent, in that we're still going to have reporting, which you all are familiar with doing. We're just saying, okay, it's important enough that we not leave it up to regulation, but that we actually put it into statute so that we have that reporting. Would you be comfortable or with the idea of that reporting, or is there a reason you're uncomfortable seeing it go into statute rather than just be part of COMAR?
If it's it's been in COMAR I've represented the industry for 23 years. It's been in COMAR for 23 years without issue. I would say, though, that the language here is inconsistent with COMAR. For example, this says on or before September 1st of each year. That would have to be altered because the cost reports are based on fiscal. So it's 3 months after each nursing facility's fiscal year. So we don't want to create a conflict.
And I'm confident that could be done. And,
Yeah.
And if that, if there's something specific like that you believe would make it a little more challenging for the industry to, fulfill the report, then certainly I think it would be appropriate. Just, let us know, hey, look, it's on a fiscal year that's already established for this period. And that could easily be adapted. You both commented that, again, and actually your opposition was fairly limited, and I think it could easily be addressed. It sounded like the cost report, and then also that there are additional positions that you think should be incorporated into those that are itemized in the bill at the moment. And I would be happy to address that, offer the committee an amendment that pulls in those additional positions that you all think should be in there. The one exclusion that I don't think would be appropriate would be for administrators and administration. That I think should be separate and apart from some of these other positions that you all indicated are of relevance. So again, looking at the two things that you particularly focused on with those concerns, I think there's a lot of room to find common ground and address that. So I would be happy to work with you and pull those things into the legislation through amendment, and maybe we could just have a happy kumbaya moment that I heard referenced is what happened in Massachusetts, and this seems to be working very well in Massachusetts. It does not contain the profit cap that exists in New York. So I think this is a very, thoughtful, reasonable, and proven piece of legislation. So maybe we can work on that common ground. Oh, sure, please. Isn't that so, Dan? And now feel free to jump in and share your thoughts.
Senator Kramer, I am very happy to sit down and have a broader discussion with you.
Not too broad, Dana. Let's stay focused.
There's a lot here, because also I want to point out that, the nursing home report that you referenced only took into account Medicaid. So when you also add the other revenue sources, we probably will see a bump, but we also have to be careful because at the same time we're only talking about revenue, we have seen an increase in our costs going up. Since between 23 and 2024, we've experienced a 6% increase in costs. Now, that is only through 2024. Everybody knows how much more costs have gone up even in 2025, so we should see more information on that through the next cost reports. So that is another issue. I also will say I'm happy to connect with Massachusetts, but I don't think Massachusetts has been as successful as may have been portrayed, but I'm happy to get more information. I've heard that nursing facilities are having a hard time meeting that because, again, it's looking at a static number when costs are increasing and rates are not increasing. And again, I just want to emphasize for 2 years, we have not received any rate increase.
And I think that the point here is that ultimately where you do see the shift, the dynamic is in the profits, maybe are, if the industry is trying to maintain those significant profits, then yes, that does make it more challenging. But if we bring the profits in line with what is being provided for care, then I think, what we want to see as these public dollars are utilized is that there's less focus on the profit side and more focus on the care model to ensure that these of our most vulnerable, these residents, are getting what they should be getting in the way of the care and services that they have paid into for the entirety of their lives. So, all right, sounds like maybe there's an opportunity to move forward, and I would welcome that interaction. So thank you, Mr. Chair.
Are there any other questions of this panel? Seeing none, thank you so very much. This ends the testimony here, and this ends the hearing on Senate Bill 663. Next, we will hear from Senator Mouse on Senate Bill 915, State Board of Physicians, delegation of duties, alterations. Senator Mouse, you only have one person that signed up on your panel. That's Danielle, but there's two others here in favor. Do you mind if they join you at the podium just to get everybody up there at once? Excellent. So Danielle, Madeline Del Grego, and Kimberly Badas.
Thanks for being here. You absolutely. Good to see you. Good to see you. Senate Bill 915.
915, Senate Bill 915, State Board of Physicians.
Thank you, Mr. Chair, distinguished committee members. It's an honor to present Senate Bill 915. Senate Bill 915 aims to strengthen regulation of medical imaging by requiring registration for limited X-ray machine operators. It establishes disciplinary procedures for these operators and clarifies duties for physician assistants and cardiovascular specialists. With a need for additional qualified X-ray machine operators, this bill supports radiologic I knew I was going to mess it up. This bill supports radiologic technology students who have successfully completed the first year of a 2-year training program by allowing them to perform limited scope X-rays. And I appreciate your consideration, and I'm going to ask for your favorable report. But, Mr. Chair, I'm suffering from, I'm taking some medicine. I can't hear. So if I miss something, please let me know. But I would urge your favorable report and turn it over to our expert witness panel. Thank you.
Good afternoon, Chair, members of the committee. My name's Danielle Varanian. I'm an attorney who represents RadNet and the Maryland Radiological Society, and we urge a favorable report on Senate Bill 915. This is an important bill, but it looks a little bit more complicated than it actually is. The only change in law that this bill is creating is a certificate that allows after the successful completion of the first year of an RT program, that student can then become a limited X-ray machine operator. That's the only change that this bill is making. The other areas in this bill that appear to be new are actually previous sections of the statute that are just being put in different places. So the information about physician's assistants, medical students, the RCISs, all of that is language that has already been in the code. So the only change here is allowing those first year RT students to take the certification of Alexmo. And that has a very important purpose, and that is it gives access to care, and there are more people that can perform these limited X-ray duties as a result of this. So with that, I urge your favorable report on this bill. Thank you.
Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the committee. My name is Kim Bathurst, and I am a Maryland licensed radiologic technologist with over 38 years of experience. 2 years ago, I testified to this committee concerning the limited X-ray machine operator bill. The end result was a collaboration on a final bill that included modifications that ultimately ensured that Maryland practicing limited X-ray machine operators had a strong education that included radiation safety, radiation protection, anatomy, image acquisition, image positioning, clinical competencies, along with supervision standards in order to practice safely with focus on quality for Maryland patients. The goal was to increase patient access to general radiography imaging at outpatient orthopedic and urgent care centers to offset ED services and patient wait times. Unfortunately, I still must report that there is a continued shortage of fully licensed technologists in the state of Maryland, along with a limited number of only 5 limited X-ray machine operators practicing that I last heard. However, noted 2 years ago, we left out of the bill a very important group of qualified individuals that could have the opportunity to become limited X-ray machine operators and assist with the shortage in general radiography in Maryland. The group we left out of legislation was that of the radiography student. Radiography students, after a full first year of education, have completed all of the LexMO education requirements in greater detail, classroom testing, clinical time, and clinical competencies than even our LexMO requirements entail today. The question is, why don't we allow our radiography students who are within good academic standing, completed 1 full year of education, along with their program director's approval of clinical competency, and has met or surpassed the educational requirements, apply and take the Maryland LexMO board? This opportunity would allow for more general radiography LexMOs to practice in Maryland and filling some of the shortage gaps in outpatient, orthopedic, and urgent care centers in imaging. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Madeline Del Greco with the Maryland Board of Physicians, here today in support of Senate Bill 915. Senate Bill 915 reorganizes Health Occupations 14306, establishes an alternative educational pathway for limited X-ray machine operators, LMXOs, and establishes disciplinary grounds for LXMOs. Currently, the board is restrained in its ability to take disciplinary action against LXMO registrants and applicants due to the lack of disciplinary grounds in the statute. This means that the board cannot revoke a registration, register an individual with conditions that protect the public, or deny a registration for failing to disclose a criminal event on an application. This is inconsistent with and contradicts the board's mission to assure quality health care through effective discipline and create significant public safety concerns, especially since LXMOs are intended to work in less regulated settings such as urgent cares. Senate Bill 915 effectively addresses the board's concerns by establishing standard disciplinary grounds for LXMOs. The board considers this addition critical to fulfilling its mission and appreciates the attention to the matter.
Thank you. Are there any questions from this panel? Seeing none, we do have 2 people signed up for favorable with amendments. That's Jason Lee and Stephanie Caldas. Y'all want to come on up? Thank you, and you all may begin when ready.
Good afternoon, Chair and members of the committee. My name is Stephanie Caldas, and I'm the Regulatory Manager for Radiology Compliance with MedStar Health Urgent Care. I oversee 34 urgent cares, and I also oversee the LXMO or the LRT program for for the DMV. And for us, for me today, I am on behalf of myself, as well as part of the RT shortage committee that RadNet was putting together, and also with the Maryland Board of the board for the society, for the Maryland Society. I have been a radiology technologist for 15 years, and I see that this LXMO program has been a success. However, just like the RadNet team had said, that we have missed on including those RT students. I do think that the education is very similar, if not equal, to what the LXMOs do currently. And I think that this would be a great opportunity for the radiology technologists to perform in the field that they're going into after their first year. And it will help with the shortage in the urgent care atmosphere. I do add the amendment where the ASRT Society, the National Society, I believe that they've also mentioned that they would like to see an amendment to the didactic hours from 115 to 150, which I have no problem with, and I think that that would meet the national recommendation from the ASRT. Thank you. I'm looking for a favorable with amendments to that.
Good afternoon, Chair and remaining members of the committee. Thanks for giving me the opportunity to provide testimony on a subject which I'm very familiar with. My name is Jason Lee, and I'm a seasoned radiology professional with nearly 30 years of experience in various areas. Not only am I an advanced practice provider in radiology, I teach radiology physicians, and I've also provided numerous lectures to limited X-ray machine operator students that are seeking roles in the urgent care setting. I come here today as an experienced radiologic technologist, as an adjunct professor for 3 colleges, and the president of the Maryland Society of Radiologic Technologists. I'm here today to speak in support with amendments for the radiologic technologist students seeking the pathway to LXMO certification. My view also does not reflect that of my employer. Our healthcare system is experiencing a significant shortage of medical imaging professionals, and I believe this will be an excellent opportunity to fill those vacancies. Radiologic technologists play a critical role in obtaining high-quality medical imaging, which aids radiologists in diagnosing disease, which can therefore help guide prompt treatment. The shortage of medical imaging professionals leads to a significant delay in care and the delay in receiving an immediate prompt diagnosis. Radiology technologists complete rigorous programs which include classroom didactic education in anatomy, physiology, radiation biology, as well as protection, patient care, as well as hands-on experience and extensive clinical training. On behalf of the Board of Directors of Maryland Society of Radiologic Technologists, we are in support of the bill allowing the radiologic technologist students to practice after successfully completing the necessary requirements, but we also encourage the increase of the didactic educations from 115 to the recommendation of at least 150 hours stated with the ASRT, which is American Society of Radiologic Technologists, LXMO curriculum. The additional hours will not only meet a nationally recognized curriculum, but will also provide them with additional knowledge and skills, prepping them to take and pass a standardized exam for them to practice. I respectfully urge you to support measures that allow qualified radiologic technology students to enter the workforce while encouraging to increase the didactic component to 150 hours. Thank you for your time and consideration.
Thank you. Are there any questions of this panel? Seeing none, that ends the bill hearing on Senate Bill 915. Next, Senator Melch, you're back at the podium with Senate Bill 917, Health Occupations, Practice of Audiology Definition. You have joining you on your panel Ashley Bagwell, as well as Dr. Shannon Pryor.
Thank you, Ashley. Good to see you. Good to see you. Thank you, Doc. Good to see you.
Senator Melch, you may begin whenever you're ready.
So, Mr. Chair, colleagues, it's a great honor to present Senate Bill 917. I didn't really realize I wasn't joking about my hearing being off. And then I realized we're doing a hearing on hearing, right? So, Senate Bill 917, it's revisiting an issue this committee is very familiar with. It's to request 2 minor changes to audiology legislation that was approved in 2024. Both changes are minor in size. They are not much, but they clarify that health screenings as well as imaging and scanning are related to auditory and vestibular conditions of the ear. Rather than get into the details, so we've heard a lot of testimony in this past, I'm going to turn this over to our expert witnesses and respectfully ask for a favorable report from the committee. Thank you, Mr. Chair and members.
Good afternoon, Mr. Vice Chairman and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of the Maryland Society of Otolaryngology in support of Senate Bill 917. As the senator said, this is an issue that this committee is very familiar with. We believe that the 2 minor changes included in this proposal provide some clarity on the language related to health screenings as well as to imaging and scanning. 2 years ago, when this bill passed, y'all will remember that the administration expressed some concern about the broadness around the health screenings language. Last year, we tried to find some middle ground on this language and unfortunately weren't able to. But at the end of the legislative session, got some guidance from the Attorney General's office, where in a letter they stated that the likely interpretation of the current statute is that health screenings are in fact limited to the evaluation and treatment of conditions of the human ear. And so we would simply request that that be codified into law. Similarly, we believe that addition of the same language following scanning and imaging provides that similar clarity. Dr. Pryor is here and can provide some more details on this, after which I'm happy to help answer questions. And with that, Mr. Vice Chairman, I will urge a favorable vote.
Good afternoon. My name is Dr. Shannon Pryor. I'm a physician and a board-certified otolaryngologist. I'm an otologist, and my practice is focused on the care of the ears. I work closely alongside audiologists when I care for my patients. I rely on them, and they rely on me. I'm speaking now in support of Senate Bill 917. I do appreciate the time and attention that this committee has given to this issue, and thank you for the opportunity to provide some additional comments for consideration. This bill is narrowly drafted, but it includes some important changes. The language as it exists in its current state is vague. The proposed language provides clarity that health screenings performed by audiologists should be related to the auditory or vestibular systems, which is in line with audiology training and expertise. And it's also in line with the letter issued by the Maryland Attorney General's office. They were asked to clarify its interpretation of the ambiguity. It also makes clear that the ordering and performing of in-office non-radiographic scanning or imaging of the external auditory canal when performed by audiologists is also related to auditory and vestibular conditions in the ear. In the one other state where scanning and imaging language explicitly appears in the statute, the scanning or imaging is limited in the same way this bill proposes. We believe that this language is important to ensure that imaging is limited to the areas that audiologists are trained to evaluate, and it will prevent unrestricted use that could expose patients to inappropriate testing. This added language brings Maryland law closer to national norms by specifying that imaging must be tied to recognized audiologic or vestibular conditions. And for this reason, we respectfully request that this clarifying language be added. I'd be happy to answer any questions, and thank you for listening.
Senator Lamb.
Thank you, Vice Chair. Been very familiar with this bill because it's come up multiple years, again and again and again. So I was looking over this, the written testimony here. From Medicaid, for example, there's a letter that's included from the Attorney General, I think that you referenced, that notes that the current law already should read that to only allow for health screenings that are related to auditory and vestibular conditions. So just to make absolutely clear, this bill is really just about clarifying the current law. Is that correct?
Yes, that's our understanding.
Okay. In looking over this written testimony as well, there is unfavorable that notes that the executive director of MedChi had agreed to different language here. Are you aware that any language was ever being agreed to?
Thank you, Senator Lamb. I can't speak to that. We did have a lot of back and forth, as I alluded to in my testimony, and did try to work with stakeholders last year. I think the issue last year that we had with the language we were going back and forth on was just bringing in insurance language into the health occupations article.
Okay. That's all I have. Thank you.
Are there any additional questions? Seeing none, thank you all so very much. We do have an unfavorable panel on Senate Bill 917. Gilligan, Alicia Spohr, and Melissa Segev.
Good. Mr. Chair and committee members, my name is Dr. Alicia Spohr, and I'm a small business and practicing audiologist in Howard County, here in strong opposition of Senate Bill 917. I urge the committee to maintain the current statute language of conducting health screenings, period. Conducting health screenings is not new or controversial practice. Since 2016, Maryland audiologists have provided health screenings under guidance from the Board of Examiners. In those 9+ years, there have not been a single disciplinary action cited for an audiologist performing a health screening. Audiologists are not overstepping, but better serving patients. The American Medical Association released 12 new audiology codes this year that specifically recognize our role in assessing vision, dexterity, and psychological factors. Audiology's national code set has already evolved to include health screenings because they are essential to comprehensive health care. Maryland should align with these standards, not retreat from them. Beyond clinical care, there is significant financial penalty for inaction. Medicare mandates these health screenings. Failure to complete them results in a 9% reduction of total Medicare payments. For a small or solo practice, this translates to thousands of dollars in lost revenue annually, a burden that threatens our viability of local clinics. Finally, the Maryland House has increasingly recognized the role of health practitioners in public safety. They have sought to have providers, including audiologists, screen for signs of human sex trafficking. If the state trusts audiologists' clinical judgment to identify a crisis as complex as sex trafficking, it is inconsistent that we suggest that we are unqualified to perform basic health screenings. Audiologists will continue to use clinical expertise to provide the highest level of patient-centered care. Please keep conducting health screenings language unchanged in the statute to ensure audiologists remain compliant with federal standards and, most importantly, patient needs. I urge an unfavorable report on Senate Bill 917.
Mr. Vice Chair and committee members, my name is Dr. Melissa Segev, and I strongly oppose locations in Maryland. I have been practicing audiology for over 18 years and love being able to improve the quality of life of so many Maryland residents. In 2024, our profession modernized to include the ability for audiologists to order imaging and perform health screenings. Last May, I saw a busy 43-year-old father of 3 who was referred by his primary care doctor. He was experiencing hearing loss and ringing in the ear and dizziness. Tinnitus, which is ringing in the ear, is associated with mental health illness. Therefore, I administered a depression screening that was negative. After performing a comprehensive assessment, his results were abnormal, and imaging was necessary to rule out a tumor. I ordered the MRI, saving the patient time and money. The radiologist called me and sent the report stat. It indicated an abnormally large tumor that was invading other brain structures. After speaking with his primary care doctor, I reviewed the results with the patient and then referred and assisted him in scheduling his appointment at Johns Hopkins. As previously mentioned, these tumors are not treated by general ENTs. Patients need a surgeon who specializes in the ear and brain. 6 weeks later, the patient underwent a successful 14-hour surgery with 2 neurosurgeons, and I'm currently treating him in my office for his unique hearing loss. The second case is a longtime patient who was seen for a routine hearing aid check, and during that visit, the audiologist asked if anything new had occurred. He commented he had ringing and spasms in the left ear. The audiologist noticed drooping of his eyes, slurred speech, and his mouth was asymmetric. She immediately performed a stroke screening that was positive. He went to the emergency room, and he was indeed having a stroke. He was diagnosed with a 70% blockage of the carotid artery. He was treated and sustained no permanent neurologic damage due to the timely intervention. Finally, skin cancers are very common in the ear, and audiologists routinely perform the ABCDE screening tool to check for abnormalities. I strongly oppose SB 917 for these reasons. Thank you again for your time.
Thank you, Madam Chair, distinguished members of the committee, leadership for decades for your constituents in the state of Maryland. I'm Gil Jen, here on behalf of the Maryland Academy of Audiology. And first, I want to thank Senator Guile for her landmark legislation in 2024. Arkansas has adopted the Guile bill. Wisconsin and Kentucky are looking at implementing that legislation. So the question is, why are we here again? And I would refer you back on February 25th, 2025, 1 hour and 49 minutes into that hearing, Ms. Bagwell said, quote, "Thank you for allowing us to revisit this bill one more time." But we're here again, and there's no evidence of wrongdoing. In fact, we have trouble understanding why MedCai comes here and wants to reverse the Hippocratic Oath of do no harm. You've just heard testimony how the Guile bill that is being rolled back by these minor amendments have saved lives. Why would you want to do that? We don't understand the logic of that. As to the Attorney General letter, this isn't a preemption matter. They did not even begin to address the MIPS mandate that they will get reduced 9% in their reimbursements. This is a federal aspect, and it deals with Medicaid Advantage and third-party payers. So we did offer a language last year to include third-party payers, and whatever they want to mandate within their health screenings, we're fine. But that was rejected by MedCai. So we ask you to do no harm and move unfavorable on this bill. Thank you.
Yep.
You guys answered the technical.
Thank you, Madam Chair. You know, I've been looking over this Attorney General's letter that was provided to MedCai. You know, you kind of touch on the issue, but you dance around it, Mr. Jen. You know, the letter from MedCai, or to MedCai, from the AG notes that the health screening language is likely already limited to health screening and auditory and vestibular conditions. So what's your concern with just clarifying that within the statute?
Would you like
if that's already, referenced in the AG's letter?
Yeah, two thoughts on that. Number one, if I can evaluate, diagnose, manage, and treat auditory and vestibular conditions related to the human ear, it lends that, of course, I can do a health screening related to auditory and vestibular conditions of the auditory and vestibular screening. So that seems a little redundant in that situation. Conducting health screenings, as that phrase alone, is addressing the bigger issue around the fact of comorbidities and or payment reductions and or requirements that we are being constantly subjected to by Medicare, Medicare Advantage, third-party payers, and it will trickle down, we believe, into Medicaid and other payer providers, that we are required to do certain things because the continuum and continuity of care is being addressed in all professions of healthcare. And so the physicians, as you well know, are screening for hearing and hopefully referring appropriately when that is positive. The AMA is now making us screen for vision in order to bill coding. I would say that vision is not auditory or vestibular right off the bat. And so when we look at dexterity, psychological, sex trafficking, all those other screenings that we are now being mandated to do, if we do not have clear language, which in statute, I will say needs to be vaguely clear. We can't line item every single health screening that can be done in statute. That's the point of regulations, and that's the point of the Board of Examiners, which has come back and told us, as long as you are within a licensed provider and you have the education you need to do a health screening, which at Walmart means put your hand into the machine and press the button, that we are able to do that. I don't know if you have anything to add, Mr.
So you
Jen.
referenced the fact that the language is, needs to be vaguely clear. I guess the concern here is that, we have an Attorney General's letter. We have letter referenced by the governor's office when this was originally signed that made clear that the language should be clearer, that it should really be limited to vestibular conditions. And so, I'm still not understanding why we can't just clarify this. And in fact, not clarifying this might leave you open to more liability.
I appreciate your concern for liability, which I know you've brought up the last 2 years when we've talked about this too. But if the federal CMS is requiring us to do health screenings and they're telling us to do body mass index, if they're telling us to do depression screening, as you heard from Dr. Segev, if they're telling us to do psychological factors in order for us to bill a code and or not be reduced in payment penalty, that I don't understand why that would be. I will finish and then happy to listen. I don't understand why that would be a cause for concern when CMS is only looking out for the best interest of the patients, primarily 65 or older and those that have disabilities, to make sure that they are getting the appropriate care when CMS is covering those services.
So you touched on CMS a few times, the Center for Medicare and Medicaid Services, and and that's been an argument that's been made here, ad nauseum, that the audiologists need the ability to do these health screenings in order to comply with Medicare merit-based incentive programs, MIPS, right? But not every state provides health screenings in its audiology law. Not every state provides that. So how are those states meeting MIPS requirements under CMS, right? There's some inconsistency here that, if we don't have the ability to do health screenings, we won't be able to be reimbursed under the MIPS system under CMS. Well, there are other states where, they're not permitted to do this. Are they being penalized under MIPS?
That's a great question. There are two answers to that depending on the state. Prior to Senator Guile passing our piece of legislation in 2024, we did not have conducting health screenings in statute, which is why we went to the Board of Examiners, looked at our regulations, and asked for the legal opinion from the board's attorney whether or not audiologists could in fact complete health screenings. And back in 2016, that legal opinion was provided to audiologists through the Board of Examiners saying that, yes, we were appropriately able to do it and that we should have the training if we did not feel like it was something that we were up to date or outside of what our didactic training might have been for a pass-fail screening, and that, yes, we could do it. There are many states that still do not have conducting health screenings in their statute. Many of them are working to change that after they've seen Maryland and Arkansas and now Wisconsin, Kentucky, and Oregon go through it, so that that is absolutely clear that they can conduct those health screenings. However, they can go to their Board of Examiners and they can look at their regulations and have that legal opinion made as well. There are some states that have said no, audiologists need to go forward and put this in statute to make sure it's absolutely clear, and those practices are being reduced at 9%, which is why these states are working so hard to get that passed and updated. Did you have anything else? No.
I mean, this isn't, so CMS doesn't decide scope of practice, right? So state law decides scope of practice. So I'm trying to understand here, what MIPS measures can audiologists do and meet without performing health screenings that are currently outside of their scope? Can you clarify that?
I can. You are correct. CMS does not dictate scope of practice. That is a state issue, which is why we were here. However, CMS does dictate how I am reimbursed through that system, which is also why I am here, and you heard about the 9% reduction. Audiologists are mandatory Medicare providers. We cannot opt out of the system. So anybody who says, well, if you don't like it, just don't accept Medicare. That's not possible for audiologists, which means we cannot opt out of Medicare Advantage. So we are stuck by the confines of these systems. These systems are telling audiologists, not optionally, but these systems are telling audiologists, you must complete, and there are more than a dozen of them currently, certain screenings depending on why the patient came in, what comorbidities the patient might have, medication screenings, everything else related to that system, because the continuity of care is not being completed in the grand scheme of medicine. And so every provider performs a medication screening. What medication are you taking? Supplements, vitamins. Again, you know this as a physician who's seen patients and billing Medicare, I'm sure, route into the system, dosage, frequency. And we're reporting it every single time we see that Medicare patient. So that's not an optional system, that's a required system every time those patients come in. And so if Medicare tells me I have to do a body mass index every time I do a hearing test or be subject to penalty underpayment, I'm going to conduct that health screening, which is asking how much do you weigh, how tall are you, and then working through that calculation. So there are a variety of them. Body mass index, tobacco screening, alcohol use. You heard about depression from my colleague, medication review, the list goes on and on.
But MIPS doesn't require you to do everything in order to be fully reimbursed by CMS. It just requires you to do some things, right? So the 9% down billing is the most that someone could be reduced, essentially if they did nothing. But you could still do things that are permissible under this, even if we were to clarify the law here with the language that's being proposed, right? So, you know, it's not that if you don't do every MIPS metric, you automatically lose 9%, right? So can you provide a citation that if you don't do every MIPS required service, you will lose 9%?
I'd be happy to send you that reference. I don't have it here. I'd have to pull up each individual measure that audiology is required to do. Some of them are a minimum of once a year. Some of them are a minimum of 50% each time you see those patients. Some of them are 100% of the time, every time you see those patients, and you have to meet the threshold that Medicare requires. Again, they're different for every.
Even with this clarifying language.
Not if it's related to auditory or vestibular conditions.
The reimbursement that is
Body mass index, I would say, is probably not related to auditory or vestibular conditions. But I have to perform it when those patients come in.
One more question. This one's for Mr. Jen. If you can, because in here, in your letter, you cite that, you know, in a discussion with Gene Ransom last year, there was agreement on written language to use as a compromise that was later rejected by Medicaid. I am not sure that that's a full picture of contention from Medicaid. So if you could please follow up with Mr. Wise or Ms. Bagwell about that, would like that clarified.
May I respond?
No.
Okay, okay.
That ends the hearing. Thank you, Senator Lamb.
Thank you.
Our last bill of the day is Senator Ellis's Senate Bill 568. Your intern's going to do it. Okay. I don't have that note. What is it? Okay. And would you like to bring up your panel? You have Dan Shattuck and I can't find it. What page is it on? It's right here. It's 77. Okay. So Dan Shattuck is with you, right, Dan? Yes. And then Sherry Goldman and Morgan Salmons will be virtual.
Yes.
All right. Go ahead. Thank you.
Good afternoon, Chair Beidel, Vice Chair Hayes, and members on the Senate Finance Committee. I am Sahithya Venkatesh, a legislative intern in the Office of Senator Ellis, who represents District 28 in Charles County. I'm presenting on Senate Bill 0568. The bill establishes a structured certification process through the State Board of Examiners of Psychologists, developed in collaboration with medical and pharmacy professionals, and modernizes Maryland's healthcare workforce to better meet growing patient demand for timely, integrated care. Furthermore, Senate Bill 0568 requires prescriptions to be issued in accordance with state and federal law and regulations and clearly identifying the prescribing psychologist and on the prescription. Senate Bill 0568 requires record of all prescriptions be maintained in the patient record and prohibits prescribing psychologists from delegating authority to anyone else to prescribe prescription drugs. 7 states, Idaho, Utah, Colorado, Illinois, Louisiana, Iowa, New Mexico, and Guam, authorize psychologists prescribing authority. Similarities exist in specialized training and certification requirements. All states require ongoing coordinated care. Coordinated care, however, varies in each state. For example, Colorado, New Mexico, and Louisiana require updated changes to be communicated to the primary care physicians, while New Mexico and Utah require reports of adverse effects to primary care physicians. In Iowa and Illinois, medical psychologists can prescribe psychotropic medications for treatment of mental health or illness. Utah authorizes medical psychologists to prescribe selected serotonin reuptake inhibitors, also known as SSRIs, which are a class of antidepressants commonly used to treat depression, anxiety, post-traumatic stress disorder, and obsessive-compulsive disorders. Members of the Senate Finance Committee, I request a favorable report on Senate Bill 0568.
Well done, thank you.
Thank you.
Dan, do you want to testify?
Yes, and excuse me, if I may, Madam Chair, I have with me Dr. Peter Smith. He had some difficulty signing up, but he'd be a great resource to answer questions.
Okay.
If I could have him.
Yeah, Barbara and I
join.
talked about that earlier.
Okay.
You can come
Thank
up.
you so much. But I'll start. My name is Dan Shattuck. I'm here today on behalf of the Maryland Psychological Association in strong support of Senate Bill 568. I want to thank Senator Ellis and his intern for bringing forward the bill and for a great introduction. This bill is very timely. Maryland is navigating, as we all have heard multiple times this year, a high level of need for mental health care. The bill before us does a number of things. It's going to address continuity of care. It's going to create a pathway for unified care with your therapist, if your therapist is a psychologist, and also allow for the coordination of your medicinal treatment as well. It improves access to care. It's going to add a qualified and trusted provider as a prescriber in Maryland. It builds on evidence-based and documented benefits of laws that have worked in 7 other states and the military, going back as far as 1994. Senate Bill 568 was crafted to include safeguards and guardrails for patient safety, coordination of care where psychologists will not be prescribing on an island. There will be a level of coordination between the medical prescriber. There'll be a limited formulary. It's going to be limited to those drugs that are used to treat mental health conditions. There's a great potential for a decrease in patient burdens as we look at adding another provider into this space, but also that coordinated care that could really do a lot to alleviate the burdens that patients face right now in terms of getting appointments or trying to renew their prescriptions or reassess their prescriptions. It also involves multi-board involvement through an advisory committee that's modeled after experiences in 2 other states, Idaho and Louisiana. You're going to hear from the virtual experts about their experiences and the benefits of prescribing psychologists, the history, its effectiveness, and its importance in this space. And again, Dr. Peter Smith will join me at the table to answer questions. Thank you for your consideration, and I urge a favorable report.
Mike. Sherry Goldman, will you unmute and give us your testimony, please? You need to unmute your little, there
Thank
you
you.
go.
All right. Good afternoon, Chair Bido, Vice Chair Hayes, and committee members. I am Dr. Sherry Goldman, a pediatrician and a child, adolescent, and adult psychiatrist in solo practice of psychiatry in Maryland since 1988. The reason I'm supporting this legislation is that access to psychiatrists is often difficult. Most patients are put on wait lists, which can last months before they're seen and evaluated. In my practice, I provide counseling and medication management. I believe that medication without therapy is not sound medical practice. Medication may reduce or eliminate symptoms, but it does not help a person develop better coping skills or change their lifestyle to better address their mental health needs. The reason that a lot of I realize that a lot of my psychiatric colleagues do not practice this way. They're content just providing medication and delegating the counseling to others. But I feel it is far better if one well-trained provider brings the full complement of mental health interventions to their patients. Many patients first seek help from psychologists. Psychologists receive training in mental health and understand psychopathology and neuroscience. So they already have a wonderful foundation should they decide to continue more advanced training to be certified and licensed to prescribe medications. This would also provide continuity of care, which was pointed out in the previous speaker. Access to mental health care is a problem in Maryland, especially in urban and rural regions. In 2025, there were approximately 4,500 psychologists licensed, 1,800 psychiatrists, and only about 300 nurse practitioners. It is my belief that we should support this legislation because we need all kinds of mental health providers. Psychiatrists will not be replaced by psychologists who prescribe medication. In fact, having the allied discipline might allow psychiatrists to address more complicated cases. Thank you for letting me mention this and support this legislation.
Thank you, Doctor. Next, we have Morgan Sammons.
Good afternoon. I'm Morgan Sammons, a psychologist and retired Navy captain, and I come in front of you urging a favorable report for SB 568. Although I now live in Oregon, I was a Maryland resident for over 20 years and was a longtime member of the Maryland Psychological Association, including a term as its president. During that time, I was in the first cohort of a program that existed in the Department of War to train psychologists to prescribe. I did so safely and effectively for almost 20 years, providing prescribing services to military members and their families in Maryland and throughout the world. In both metropolitan areas, where I worked alongside my psychiatric colleagues, such as the National Naval Medical Center in Bethesda, and in places where no mental health prescribers existed, such as in Iceland or combat outposts in Iraq, I was able to assist service members and their families with both psychological and pharmacological treatments. I prescribed a full range of psychotropic drugs to treat active duty members and their dependents. I treated diagnoses from depression to severe psychosis with a full range of drugs, from agents to treat insomnia to lithium and powerful antipsychotic drugs. All psychotropic agents have some degree of risk. Several, including lithium, require close monitoring. As my training gave me the ability to interpret laboratory findings, I was able to administer these complex regimens safely. Maryland faces a shortage of qualified prescribers of psychotropic drugs. It's been demonstrated that in states where psychologists have been given the ability to prescribe, that they have safely and effectively assisted in alleviating problems of mental health access. Safety is an issue for all providers, no less so for psychologist prescribers. But the safety record of all non-physician healthcare specialties that have been given prescriptive authority is clear. Professions who add prescriptive authority to their scope of practice have uniformly done so safely and effectively. Allowing psychologists to prescribe will be to allow mental health only where indicated into treatment, because psychologists are fundamentally trained in behavioral and psychological interventions, not just medicine. We are best equipped to provide a complete range of mental health services to patients rather than simple medication management. The program I began in 1991 was an experiment, but with psychologist prescribers in 7 states, the Department of War, the Indian Health Service, and U.S. Public Health Service, we have become an accepted component of comprehensive mental health care who have a track record of proven efficacy in meeting rising healthcare demand. I do urge the committee to provide a favorable report on SB 638, and I'm happy to answer any questions you may have.
Thank you. So do I have any questions? Wait, Senator Reedy. Okay.
Thank you, Madam Chair. I wondered if I could ask Dr. Smith. I've been wrestling with this bill because I've had people come see me kind of on both sides of it, and the concerns anytime we're expanding prescription authority should be done very carefully. I know we all agree with that. Your contention would be there are delays in treatment because someone has to get to the psychiatrist to properly get the prescription.
Evaluated or initiated on a medication regimen if appropriate.
But you as a psychologist are qualified to recommend that they need a medication treatment, but they still have to go to a psychiatrist, or what?
At this time, yes. At this time, if I saw a patient and thought that their depression was severe enough, or if they were struggling with a bipolar disorder, I would then have to refer them to a psychiatrist. And research is relatively clear that there are long delays with a lot of obtaining psychiatric providers. Other obstacles include the lack of psychiatrists accepting insurance, so there's a cost barrier as well. When we have from APA over 60% of psychologists accepting insurance, and you have some surveys showing that psychiatrists, only 10 or 15% of them will be taking insurance, that's an additional burden.
They would only take insurance for the visit, or for the medication might be covered by insurance?
The visit, and so the out-of-pocket costs initially can be quite expensive for patients going to see fee-for-service for psychiatric
Maryland
services.
psychiatrists don't take insurance?
Many do, but some surveys show that their rates are decreasing. For example, participation in Medicare Part B, it's only about 25% of psychiatrists participate in Medicare Part B, and you're seeing that psychiatrists in general are moving away from insurance-based practice, and a lot of them, by surveys, are moving toward more of a fee-for-service. So there ends up being a cost burden.
I imagine it's somewhat of they're overwhelmed too, and then also, yeah, interesting. And then I mean, the big objection that I would have to expanding this, I think the bill has some categories of drugs that are pretty powerful stuff. What is the training regimen? How could you explain the training regimen that you go through relative to what a psychiatrist goes through to titrate the drugs, to manage multiple drugs?
So to become a prescribing psychologist, and I'll speak broadly because there are 7 states and there's some variations across the board, you have to become a licensed psychologist first. This is your post-baccalaureate degree, your doctoral degree, so that's 5 to 6 years of training, internship, fellowship, licensure, and then before you can begin to move into the next step, you have to then enroll in a postdoctoral Master of Science in Clinical Psychopharmacology. That's a 2-year program focusing on areas such as pathophysiology, pharmacology, clinical psychopharmacology, clinical medicine, interpreting lab tests. This is in addition to your doctoral degree, and this separates prescribing psychologists from psychologists who do not pursue this.
And that's what this bill would set up.
Only for those psychologists pursuing additional training, academic training, and then passing a national exam, and then participating in a clinical fellowship, all under the supervision of medical providers to provide that additional training. So this bill is not to allow every psychologist to prescribe, but only those who pursue this additional training in medical training by faculty who teach in medical schools, and these 7 designated programs, to then go forward and add this tool to their toolkit. As Dr. Salmon said, psychologists, and there's a practice in New Mexico that had a study about a group in New Mexico prescribing psychologists. 60% of their patients were being seen for medication and therapy at the same time. So that's non-fragmented care. There's a cost benefit when you don't have to have multiple appointments.
Okay. Thank you. I appreciate the insights.
Of course.
Senator Ellis.
Quick question, Madam Chair. Thank you for being here, testimony. Besides MD psychiatrists, any other professional class in Maryland have prescriptive authority in this area?
Yes, physician assistants, nurse practitioners.
Okay, thank you. Thank you, Madam Chair.
I don't see any other questions from this panel. Thank you very much. Now we have 3 unfavorables: Cynthia Lewis, Matthew Edelstein, and Steve Wise. And then we're going to have 4 virtuals, and that'll be the end of our hearing today.
Good afternoon. Thank you so much for hearing me today and for this committee's persistence through all of the testimony. My name is Dr. Matt Edelstein. I'm a clinical psychologist. I'm speaking on behalf of the Board of Examiners of Psychologists of Maryland. I also work at the Kennedy Krieger Institute, directing a program in severe behavior, and I'm an assistant professor at Johns Hopkins School of Medicine. I'm not speaking on behalf of my employers. I appreciate the opportunity to testify on SB 568, which provides prescriptive authority to certain licensed psychologists who are seeking that certification. I want to highlight that the board is philosophically in support of prescriptive authority. However, as you'll see in our letter of concern, there are several elements of the bill that warrant additional attention. And so just to sort of cut to the chase, what we're hoping that this committee will do will vote unfavorably on this bill, but approve the board for a summer study. Some of our specific concerns relate to how competency is defined. Several of those points were already highlighted today, but I'll mention that that several states have competency requirements that far exceed what the bill is requiring, this particular bill, which leads us as a board, some concern of protecting the public. There are other items on the bill that we think requires clarification and board input, and so we request that we conduct a summer study to collaborate on the development of the bill. Thank you.
Thank you, Dr. Edelstein. Cynthia, you want to go next?
Yes. Good afternoon, Chair, members of the committee. Thank you for the opportunity to testify today. My name is Dr. Cynthia Lewis. I am Director of Adult Psychiatric Emergency Services at the Johns Hopkins Hospital. I am co-chair of the Legislative Committee for the Maryland Psychiatric Society, and I stand in respectful opposition to Senate Bill 568, giving licensed psychologists prescriptive authority. The views today are my own and of the Maryland Psychiatric Society, not that of my employer. While psychologists play a vital and valued role in delivering mental health care, they do not attend medical school. Physicians complete 4 years of medical school, followed by 3 to 4 years of residency training, accumulating over 12,000 to 16,000 hours of supervised clinical experience managing complex medical conditions, pharmacology, and systemic disease. In contrast, the additional training proposed under this legislation represents only a fraction of that preparation and does not provide equivalent depth in physiology, pathology, or the management of medical complications. Psychotropic medications are powerful agents that affect cardiovascular, metabolic, neurologic, and endocrine systems. Safe prescribing requires the ability to diagnose and manage co-occurring medical conditions, interpret laboratory findings, and recognize drug interactions across organ systems. A limited postdoctoral prescribing certificate cannot substitute for comprehensive medical training. Furthermore, this bill does not meaningfully improve access to care. Medicare currently does not reimburse psychologists for prescribing services, meaning many seniors would not benefit from this. Access challenges are more effectively addressed through proven strategies such as collaborative care models, where primary care physicians, psychiatrists, and psychologists work together, and through expanded telehealth services that connect patients to board-certified psychiatrists statewide. Maryland should prioritize strengthening integrated team-based care rather than creating a new, inadequately trained prescriber category. Expanding telepsychiatry, incentivizing physician recruitment, and supporting collaborative care will improve access without compromising patient safety. For these reasons, I respectfully urge the committee to vote unfavorably on this legislation. Thank you.
Good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. I'm Steve Wise here in opposition on behalf of MedCai. And I want to just quickly thank Senator Ellis for taking a couple minutes to talk to me about this bill the other day as I explained our opposition. Just 2 points from me, because I know you have other far more qualified individuals than myself lined up virtually. But one thing I did want to note to you about the bill is traditionally when boards are given standards before granting certain authorities to folks, if it's education related, there's an accrediting body, an independent body that says, yes, this level of education in this institution meets some objective criteria. In this bill, at the bottom of page 6, the qualifications say that they've successfully completed an educational program recognized by the board. So that leaves it entirely in the discretion of the board as opposed to what you normally see, which is a separate accrediting institution. And then secondly, I wanted to respond to Senator Ellis's question about PAs in particular. PAs still operate under collaborative agreements with physicians under which the physician can limit the prescribing of the PA. So for example, if you didn't want them prescribing opioids, you could say that in your agreement. So with that, I'm happy to answer any questions. Thank you.
Thank you. Do I have any questions for this panel? Senator Ellis.
Keeping with the hour. Thank you, Madam Chair. And so, Dr. Lewis, thank you for all you do. I mean, there's a shortage of folks, doctors, psychiatrists in city areas, rural areas, and I represent Charles County, which is considered a rural area. And I know of constituents have told me how they have to wait so long to get in to see a psychiatrist. And the idea behind this bill, why I like it, is basically it increase the level of service available because we have quite a few psychologists in the outlying areas. And you mentioned that, the psychologists don't have medical training, but neither do, they don't go to medical school, but neither do nurses or PAs. And Mr. Wise, you said, PAs are still basically work with doctors, but the psychiatric nurse practitioners, they have full prescribing authority. So how would you kind of weave those professions, Dr. Lewis, in your testimony?
Yes, thank you for the question. One, the access. So what the studies are showing that these psychologists who are gaining prescriptive authority, they're still remaining in the urban areas from what the data is showing. In the urban areas, we have a lot of access to care. I was in the National Health Service Corps, and I had to spend time on the Eastern Shore. So there are ways that we can get more treatment and providers out to the rural areas. We also have telehealth. We have, again, these collaborative care models. 988, which is rolled out, they have a option with their program where if someone calls that number, they will find people access within a week. So there's a lot of opportunities and resources out there. We just need to make sure that people know them. But again, 80% of our patients are being prescribed medicines by their primary care physicians. And then we have our psychiatric nurse practitioners who, although they're not physicians, but they are nurses. And nurses, their training is medically based. They learn the systems. Psychologists are more social, kind of environmental. They don't get the medical background. So there are, through telehealth, through collaborative care models, through our primary care physicians, through our psychiatric nurse practitioners who in Maryland have kind of exploded since we've given them the authority. And there are other, mechanisms that can get people seen in these rural areas.
Okay, thank you. Thank you, Madam Chair.
Thank you, Senator. Okay, that ends this panel. We're going to go to the last virtual panel. We're going to start with Mr. Ronald Means. If you'll unmute and give us your testimony, please.
Yes, thank you, Madam Chair and committee members. My name is Dr. Ronald Means. I'm the president of the Maryland Psychiatric Society, and I'm here today to testify in opposition to Senate Bill 568. The key point in this, which has been stated, is that in order to prescribe medication safely, a practitioner must have adequate medical training. Psychologists don't have such medical training, and the proposed education offered as part of this bill is far from adequate. The complexity of psychiatric prescribing is underestimated, and in no other area of medicine would we even consider allowing a professional without adequate medical training to prescribe medication. One must have the medical knowledge necessary to ensure that medical illnesses, like physical problems, are not the root cause of the apparent mental health symptoms, as numerous medical conditions can mimic psychiatric symptoms. It's critical that a prescribing professional understand these other conditions and their presentation so that they can identify them and avoid erroneous prescribing. Although very effective in treating mental illness, psychiatric medications can have dangerous impacts to various body systems, including the heart, the liver, the kidneys, the thyroid, pancreas, many other systems. Treatment with some psychotropics can cause diabetes, high cholesterol, life-threatening rashes, life-threatening reductions in blood counts. And nearly half of the medications that we use require regular laboratory monitoring. In order to order and understand these tests thoroughly, one must have medical training. In fact, some medications we use actually require a routine physical examination of a patient that certainly requires medical know-how. As stated previously, Center for Medicare and Medicaid Services does not recognize psychologists prescribing. There's good reason for that. Legislation like Senate Bill 568 would allow for the most vulnerable people to be subjected to substandard care. It would allow geriatric patients, those with severe mental illness in combination with substance use problems and medical problems, pregnant people, even kids, to receive medication management by inadequately trained practitioners, thus subjecting them to poor outcomes. We can't let the unlikely hope of expanded care outweigh the known poor outcomes that will come with dangerously uninformed care. And because of that, we are standing in opposition to Senate Bill 568. Thank you.
Thank you, Dr. Means. I think next we have Dr. Jacob Swartz. If you will unmute and give us your testimony.
Can you hear me okay?
We can hear you. Thank you.
Beautiful. Hi, good evening, Chair and members of the committee. Thank you so much for this important opportunity to speak out in strong opposition to Senate Bill 568. My name is Jacob Swartz. I'm a child and adolescent psychiatrist working in Montgomery County, also representing the Washington Psychiatric Society and Maryland Psychiatric Society. We strongly oppose this bill seeking to give prescription authority for medications that have wide-ranging potential effects, not only on the brain, because in order to get to the brain is one of our most guarded organs, lungs, heart, liver, muscles, and endocrine system. I've had several other colleagues who are going to speak to other aspects of concern, but I really want to highlight the particular difference and lacking of medical training that is proposed. A psychiatrist is a mental health professional who completes medical school, including 2 years of intensive preclinical work, 2 years of intensive clinical rotations, rotating with internal medicine doctors, surgeons, pediatricians, obstetricians, and gynecologists, among many others. We then complete a 4-year residency, including over 6 months working with supervision as hospitalists, as well as in neurology rotations. These are years of seeing and treating illnesses, learning physical exams, laboratory results, as well as observation and clinical supervision, prescribing medications. When it is all said and done, we average about 16,000 clinical hours to independently manage and prescribe medications for our patients. This bill seeks to allow prescription of potentially dangerous medications and controlled substances, by the way, with as little as 400 hours of pharmacology training, which 40 hours per week, that's 10 weeks, and limited and unclear medical rotations, and 100 hours of supervision treating patients with medication. That includes prescribing to medically complex and vulnerable population, as well as children and adolescents. Psychologists are valuable and knowledgeable members of our treatment team, but this is an unsafe bill, and our patients and community deserve safe and well-trained experts managing their medications. Thank you.
Thank you, Dr. Carol Vidal.
Thank you. Good evening, Chair Bidel and members of the Finance Committee. I'm Dr. Carol Vidal, a psychiatrist and associate professor at Johns Hopkins University, and I'm not speaking on behalf of my employer, but on behalf of MPS and WPS in opposition to Bill SB 568 that would authorize psychologists to prescribe medications. It's a lifelong challenge for any psychiatrist to explain the differences between a psychiatrist, a medical doctor, and a psychologist, not a medical doctor. But it is imperative that lawmakers understand the difference for patient safety. And you've heard my colleagues explain these differences. I want to speak now about the argument from the proponents of this bill that it will increase access. There are many safe ways to improve access to mental health, and these include timely treatment, telemedicine, incentives for professionals to practice in rural areas, and most important, care coordination or collaboration with other professionals like primary care physicians who are trained in all systems of the human body. Maryland also is not Iowa or Idaho. We are very privileged. We have 2 training programs in Baltimore and 2 programs in DC, producing dozens of psychiatrists yearly who stayed here, and which would help with any shortage of prescribers in the state. And additionally, Medicare does not reimburse psychologists prescribing, as it has said before, which means that giving prescriptive rights to psychologists will not increase access for these patients. And while some rural areas of Maryland are indeed underserved, psychologists are not practicing in high rural need areas once they gain prescriptive authority. They stay in urban areas. I think by now most people have come to understand that prevention is key for any type of health condition. Increasing the number of people who prescribe medications is not necessarily the answer, simply because what we need is more emphasis on informal community care, mental health services through primary care, and psychotherapy. In other advanced and well-coordinated public health systems like the UK, high-cost services such as psychopharmacological treatment are provided at lower frequency and only for very sick patients. For the general population, we need more therapists and less poorly trained prescribers. I think for these reasons, I oppose this bill. Thank you.
Thank you. Do we have any questions for this virtual? I know I have one more person that's information only, but for this particular panel that's unfavorable, do we have any questions? Senator Ellis, go ahead.
Thank you. Thank you, everyone, for all you do in a critical need area. A quick question for Dr. Schwartz. I really appreciate the saying how many hours of total training, 16,000, and definitely hats off to you and the profession for the rigor of your training. So quick question, do psychiatric nurse practitioners and physician assistants who have this authority have 16,000 hours of training also?
No, which is a different question for a different day on some of these aspects. However, again, like we've talked about.
Did you say no?
No, that's purview of the psychiatrist because you have to go through medical school on the 4 years. Yes.
Okay, great. Thank you. Madam Chair.
Okay, that's no more questions for this virtual group. And now we have Philip Hughes to give us information.
Good afternoon. It's good to see you all. My name is Dr. Philip Hughes, and I'm an assistant professor in the School of Pharmacy and Pharmaceutical Sciences at Binghamton University. For the record, this testimony is my own and not that of my employer. I've submitted written testimony, which is significantly lengthier to you all, but I wanted to highlight a few key findings. So first, I wanted to talk about safety. I recently published a peer-reviewed study comparing the outcomes of over 21,000 patients who saw a prescribing psychologist or a psychiatrist. This study used the same robust methods used by the FDA to generate real-world evidence for drug safety. Compared to patients treated by psychiatrists, prescribing psychologist patients had a 24% lower rate of adverse drug events and a 20% lower rate of using multiple psychotropic medications, and similar rates of emergency department visits and medication adherence. Put shortly, prescribing psychologists appear to be at least as safe as psychiatrists. And I want to note that this data comes from states with competency requirements that are equivalent to those in the current bill. They're not from the states that require the additional lengthy rotations. And I also want to highlight that this finding includes, this study included patients with a wide range of co-occurring conditions. So, complex conditions affecting the kidneys, lungs, the cardiovascular system, all of those were included in this, and those were still the findings. There's also ample evidence to suggest that prescriptive authority for psychologists can improve population mental health. Specifically, 2 studies have now found that suicide rates are lowered by as much as 5 to 7% when psychologists prescribe. Finally, this bill is likely to increase access to mental health services. I led a workforce study simulating that this bill may reduce mental health prescriber shortages in Maryland by almost 9%, 8.8% specifically. So the research to date has clearly demonstrated that prescriptive authority for psychologists is safe. It reduces suicide rates and reduces healthcare costs and improves access to mental health care. And with that, I am happy to take any additional questions.
Thank you, Dr. Hughes. Do I have any questions for Senator Ellis?
So thank you. Is it Dr. Hughes or Mr. Hughes?
Dr. Hughes, please.
Dr. Hughes, thank you. And so I was wondering if you have any reference the statistic you shared. And I looked at your testimony, and you referenced all your facts with appropriate research. So thank you for that. Thank you for your testimony.
Certainly.
I don't see any other questions. That ends the hearing for Senate Bill 568, and it ends the hearings for today. Thank you.